I'm a little bit late, but hey, 5 minutes is a crazy difference for my normal lateness, I guess. So much going on. So much going on, but too little time. Here, cool. Alrighty. Gonna drag right on up here. We're gonna watch that subscriber count go on up. And then we're gonna watch this guy too. How's everyone doing? Who all do we got in here? We got Moon Phase Gazing. We have Craftastrophe. We got Mochi Mom. We have SKRR80P. We have Sherry Rose. Alrighty. Alrighty, we're getting this started. We got a total of 9 people in here right now, which will change here in just a couple seconds, obviously. But, nonetheless. Let's see. What do we got going on? We have Cass. We've got Ashley Wynn. Ashley Wynn, where and why? I wonder how they spell where and why in Vietnamese, right? It's kind of funny, right? That could be a really well-written joke if I fleshed that out. I don't know how I'd use it ever, but, you know, one of those situations. Dude, my hair is so, like, flat today. It's odd. It looks like I'm wearing a wig. I could do, like, a bowl cut. Do the broccoli, yeah. Broccoli, not Rock Lee either. I mean, technically Rock Lee, yeah. Bruce Lee haircut here. Just pop it right there. It'd look pretty legit. I don't know. I'm gonna do the 2-inch punch. You know? Hey, guys. Hey, Sarah Bell. Hey, Lib Slayer. Great to see you guys here. We got 35 people in here now. Heck yeah, I'm gonna start playing this video as soon as, let's see. Did I upload this yet? I did not upload. Oh, man. Okay. So as soon as I do that, I gotta do a quick thumbnail real quick. Hold on a second, guys. I gotta shut off my full screen. Gotta make myself bigger. I gotta shut off the sub count. Okay, there we go. I gotta do this. I'm gonna have to look serious. What? Let's see. I'll hit record and then I'll do, like, I'll strike a. There we go. Something like that. Okay, good enough. And then you're gonna see me pull this up. Strike a. Oh, wait. Let's have this muted. And then, of course, I gotta do that. Oh, of course. There we go. Something like that. I hate this thing. Oh, okay. Or don't mute it. There we go. All right. Okay. Go away. There we go. Bam. Bam. There we go. I'm having this video come out at noon, and I got to do the thumbnail for it, and I'm going to need at least something like that. I'll put myself on a layer here. Sorry, guys. I'll be working on a thumbnail in the background because I did not take care of this thumbnail yet, and yeah, not good. There. Am I way off? Yep. I'm way off. Oh, I'm not way off. That's about the right size of my chair in the background. On my thumbnails. Doctor up quick. That off. There. All right, there we are. Good enough. Okay. All right. Awesome. Let's get back to details here. Alrighty, here we go. Let's see. We've got Eric Goss. Hey, and Pure Madness. Hey, guys. Didn't see scrolls. Morning, everyone. Good morning. It's great to see you all here. Alrighty, we're going to go ahead and I'm going to start this video here. It just started. So we're in trial now. I'm going to make myself smaller. I'm going to bring back the sub count because I think I'm going to make this a normal part of the day. So we'll do that. Yeah, that looks good to me. There we go. Kind of. There we go. So that way, yeah, that gives just enough space. All right, we're going to get started with this. It just started. We're not far behind at all. I'm going to put this at like 1.25 speed. You won't even notice, but it'll catch us up. I think we're like 4 minutes behind. So let's get started onto this trial. I'm going to play this. I'm going to be interacting with you guys, and I'm also going to be making the thumbnail and upload this video, which will drop at about noon today. So there's that. It's also available for members only early. I don't know if y'all are going to want to watch this on the side or something like that, but we'll see what happens. So anyway, volume good here. Apparently there's sound. It's registering sound from this, but I don't hear anything. Huh. Glad to see my gates work and stuff. Okay, here we go.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251-403.
Yeah, they're like 40 minutes late.
State of Utah versus
Wonder what happened.
James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard for the
We
state.
are 10
County
minutes
Attorney
behind.
Jeff Gray also
Come on.
present.
Good morning.
But the speed, we're more like 7 minutes behind. So we'll catch up in about
Good morning,
15
Your Honor.
minutes. We'll be
Kathy
fully caught
Nestor,
up here.
Richard Novak, Michael Burt, and Stacey Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
So give me a second, guys. I'll be with
Good
you
morning,
all here in
Mr.
a second. I'm
Robinson.
going to upload this video.
And for the record, the court also recognizes the presence of Ms. Erica Kirk. Sorry. Good morning, Ms. Kirk. All right. As you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer, and I
Right
invite you to
now.
do the same.
I'm looking at you, Mr. Novak.
Every person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall
Hey,
be
McKinsey.
quiet.
Thank you for
civil
stopping
and
by to say
orderly.
hi.
Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons,
Ooh,
signs,
South Korea's getting
clothing,
taken over by
or
China,
photographs
huh?
expressing support for or against any
We'll have to
person
look into
related
that.
to this case or the status of this case as a capital offense. All right. As we begin this morning, I wish to, I've taken a lot of time to think about the comments made by the parties yesterday,
go away?
and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we've came back on record. One of the motions filed last night was filed by
They're quiet again.
Ms. Erica Kirk's attorney, and I wish to address that. And I
There we
realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so. And I don't believe that the issues that are presently before the court going forward with
Thumbnail.
the hearing
I will
with
be
respect
done with this in
to
a second.
exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
What are they bringing Tyler's parents in? Oh.
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process, and I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of
Did
course,
this guy
the
have
media
some
believes
helium before coming in?
the media will be the party who stands here at this lectern and says, we believe we should see as much as possible, maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we, of course, support that.
Thank you.
By the way, we're watching this on
All
the
right.
AP today, guys. You should go check them out if you ever want to see this stuff without like any interference or interruptions.
All right,
Just
so
wanna
I want to
put- I'll
address
put it out there. It's
the
only fair to
motion
them.
filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it
My
all
gosh,
addressed.
it's Candace Owens' picture.
So in regards to
That
that,
drop
and I
truck.
appreciate the position of the parties,
like
it is
Edie
important for me to
with
hear
her
all sides.
filters.
Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness,
amazing.
respect,
If
and
Edie comes in
dignity,
here, I'm
and
showing
the
her
right to be
that.
present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Ms. Robinson's constitutional rights. I'm sorry, Mr. Robinson's constitutional rights,
Ms.
Ms.
Robinson,
Kirk's
yeah,
rights
don't
as a victim
misgender
representative,
the boy.
and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent.
He's a man.
Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights
Boy,
and
man.
protections afforded to
Boy,
all
McCain.
parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that
That
motion.
infinity
All right, counsel, the
and
last
beyond?
matter, as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing
choice. Use it when you
from
need
last
it.
night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that
I
correct?
do. And there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record,
Okay.
and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Be a good word. What's a explodes? Like she's going off the freaking rails. Trying to think of a good. Sorry guys, I do not have chat pulled up. I'm trying to finish this real quick. I will be right with you
Your
guys.
Honor, and then
in
let's just
a
see what the
few.
court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were
yes
exactly
or no
as
would
the
be
court
way more
ordered,
direct,
but we
but okay,
noticed
guy.
that the video,
Whatever.
which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night.
Oh God,
I
this guy
believe that
sucks.
they ultimately forwarded to the court what I'll call
He
version
just
2
sucks.
of the redactions.
Nobody likes
which
him.
redacts the video
Get him out of here.
that would have made
Don't
the audio
give him his
redactions
jacket.
sort of
Get him out.
superfluous or ineffective. So that's sort of where we are. But I
Pretty much
we
we're
may
in
be
timeout again today.
not
They're going to
communicating with each
screw
other
around
about
with
the
this
same
whole
issue
day.
much.
We're not going to get
Well,
any evidence.
I just
of
want to
these
make sure
problems.
that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus, the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is where I'm going to next. Mr. Ballard?
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here, and this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page, based on what the court just said.
Your Honor, I think we have just a 1 second difference. Our timestamp is 2522 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second, we are all in agreement
Oh, really?
about this.
So what's the problem
that
with
the court,
Novak
and
there?
it sounds like you're one step ahead of the court. I was going to say that if you had it you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are two additional changes as well. And this is very short, and so I'll leave it to the state. If you wish to just in real time pause and fast forward or wish to redact it, I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach. When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence, and I would like to be able to point the court to those. We've got two brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript
I do.
in front of you? Okay. First of all, at the very, very bottom of page 10, beginning with the words, "was he," and then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see. Right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until
16, the timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19.
Right, finally.
And it begins,
Got it. It's all done now, guys.
let's see.
We did it.
It would be the fifth paragraph down, Mr. McBride stating "okay," and then ending at
Danny.
timestamp
Danny
3340.
McBride. Whatever happened to that guy? Does he still do
Again,
stuff?
that's not cumulative of any anticipated exhibit, and nor does it refer to any
And there's chat. Here we
admission by
go.
the
Thank you
defendant.
guys for being patient.
Thank you.
Cool. I'm glad I didn't miss it.
Yes, you may.
I would have felt bad. All right. I think I got everything. Is Edie in here? I want to show her this. Very funny.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the
Can make
court.
a Korean
Of course,
music channel that
that
talks
was
about
not
it?
a section
Okay.
that
I
we
appreciate
asked
that.
the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted, redacted transcript,
See that?
and the court agreed with us.
I can show you guys why.
This is not relevant.
Double A suck.
This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency in reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript.
Why do I need this
which
much?
we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue
1
prejudice.
9-volt would have done better. 1 9.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant
They're
nor
still arguing
probative
over a video that they were arguing
of
about
anything
yesterday at Showing.
of significance, especially
we're not
compared to
missing
the
a
undue
thing.
prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
This is not 1.2, right? Yeah.
Thank you, Your Honors. Mr. Novak
minutes
recognized
behind.
Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him, and then also it's very relevant to the enhancement that we have charged.
All right. Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again,
Hey,
citing
thank you,
to
Amanda.
page 10, and I know it's to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 15:39 on the video, starting with was he, and ending at 16:46, with the last word asking. After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in
Mr.
what
Twiggs.
is or is
Yeah,
not
I love it.
published
Isn't it
to the
great?
public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327,
Now, who requested Dirty
going
Deeds?
to just before 3340.
Out of curiosity, guys? Like,
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. Right after 3255, where
All right.
Mr. McBride states, okay.
I see. Thank you. Let me just take a quick second to review this.
who was that?
In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again,
Right.
as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with OK, ending at 3327, is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note the, and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds
Hey, Grits.
independently that this
The Discord link, I think, is pinned.
this portion
It'll be the very first link in that pinned comment.
shall not be transmitted into
Or
the courtroom.
or in the description.
Because of certain
The description
statements
has
made
a
in there
permanent link.
that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK,
Okay.
until just before 3340. I'm sorry, up to 3340
Base.
may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
Good.
And so this is the
Good. Can we
appropriate
see the video
balancing
now?
of being transparent while at the same time maintaining the constitutional rights
Somebody
or balancing the
transparent.
constitutional rights of all parties and what is
Already slick hair
appropriate
trolls.
for
Heck
publication.
Yeah. Heck
And
yeah,
this may
Blank
be
of the
published
Beat.
not only
Let
to
me
the
get this
gallery,
collar fixed.
but to
But it's all
to the
messed
media
up.
as well. That goes beyond the gallery itself. All right.
Use my iron on this.
Anything
stuff,
further
but
on State's Exhibit
irony is
16?
for women.
Not from the state, Your Honor. Thank you.
No, I'm
All right.
iron's fine.
And I note the defense is nodding their head as well and
Okay.
not
Everyone's in
indicating any
agreement.
more is needed to be discussed at this point.
Play it.
All right.
Let's go.
I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
All right. Good. It's done. We only wasted an entire hour in 7 minutes of everyone's time. Let me
Thank you, Your
fast
Honor.
forward.
We would just like to briefly
Oh.
emphasize a few points in the briefing that we filed early this morning. Last night, the
stubbed my
state,
toe.
or excuse me, the defense raised the
My wife
issue
was
of
angry.
publicizing, or publishing,
Someone
excuse
stole
me,
my cat.
publishing
Your Honor.
admissions by the defendant or
How do you
confessions.
plead?
They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today.
Get already a hair commercial? Heck yeah.
Estes cited
Slow
to the
life.
dissenting opinion in Rideau, which is very curious because that
Whatever.
dissenting opinion, Rideau was a change of venue
Heck
case.
yeah, I'm down.
And what the dissenting opinion held
long
is
as
that
they
the
give me
court
money.
properly refused to change venue in that case,
Then they,
even
forced
though
me to side
the
with
defendant's
Israel.
confession had been televised multiple
That's how hair
times.
commercials would work.
So it's,
you know,
it's
they gotta be
puzzling
bought out.
that that's what the
They got to buy me out,
Estes
right?
court would rely on
According to
as
Candace.
supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence. And Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then they immediately, it was the police that immediately
Well, now,
released
how
that
do you
recording
define leading
to
questions
the
here?
press, who then publicized and televised that.
That's kind of an
The
accusation,
defendant
isn't it?
confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant
Or was he
voluntarily
saying
made
leading statements to
to
the-
close
the
friends and associates of him and his roommate.
Estes case or whatever. In Estes versus Testes, I guess.
Sorry, just one other
Trans
point
courtroom is,
about Rideau and that dissenting opinion. It's
Estes versus
interesting
Testes,
that in that dissenting opinion, that
that's
judge
so funny.
that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory
guys
that's
are too
completely
nice.
sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value, and even if it did, the circumstances are completely different than from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing,
Oh, yeah. they're gonna
especially
get
just
paid.
in
We can already
court,
tell. They started
the
off
defendant's
being paid.
voluntary admissions.
In this,
I think the most
An hour
interesting
ago, I
case
guess,
is the
they
Sixth
started.
Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
not this time.
well, we'll see where that goes. Here's Novak again.
Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession
And he goes,
was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial.
okay.
This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's
Yeah.
counsel. The state wants to publish
Growing his hair out.
what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the
Make this smaller.
blanket rule that there is unrebuttable prejudice. It's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial
Why is there like a
publicity makes them an unfair,
patch
makes them
here on the back of
unable to
his head?
serve.
That's like perfect.
But there is an extreme case. That's not my language. That's the
Indented.
Supreme Court's language in
you see
Skilling.
what I'm saying?
There are extreme cases of pretrial publicity where
guy going to the
prejudice is going
Matrix
to be
often?
presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case
Tracy, don't be
that
a
the
quitter.
Supreme Court talked
Don't
about
you
in
take
Skilling.
a break from smoking.
We wouldn't have any state action
Put 'em all.
giving rise to this
Get 'em
problem
all.
if we didn't have cameras in the courtroom. And that's why we think that Exhibits 16.1, 16.2, and
Smoking
16.3
bad.
need to be
Smoking
managed
bad.
in the way we've asserted. Thank you, Your Honor.
Thank
You're
you.
not welcome, Mr. Novak.
Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. Not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public. And the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on.
That's a fair
And
argument.
that,
That's a fair
is
argument.
even more.
Check it out. This is really smart. This is a really smart argument. Mr. Novak made the argument that, hey, if this wasn't public, we'd have no problem publishing it. But here's the difference. The court should not be going a different route just because, okay, well, the court's going to be public. Oh, okay, well, now we can't do certain things. No. That shouldn't be allowed at all. The cameras being in the courtroom should have no effect as to what actually takes place in the courtroom. That shouldn't change anybody's mind. It shouldn't do anything. You allowed it to be a public hearing instead of a private hearing. Therefore, everything should go about the same way. That is an incredibly smart argument. We should not be having a different type of argument whatsoever. So, we should not be having a different type of court whatsoever. You can either do it privately. If it got ruled to be private, everything goes the same way. If it got ruled to be public, well, okay, now everything's public. We should not be changing our demeanors. We should not be changing our arguments. We should not be changing our evidence or anything like that because it's a public court. So I absolutely agree. If they thought this stuff was going to hurt Tyler Robinson at all, they should have made it a private court. They should have kept the cameras out of the courtroom. They decided not to. That's what they reap. That's what they've sown. That's the consequences of it. That's how it went. Too bad. Tough. Get on with it. I agree with this dude 100%. That is a very, very good argument.
More important to the victim representative's right to be able to be present and to observe these
Little
proceedings.
Too low.
Thank you.
Hey, thanks for the compliments on the shirt. I've had it for a while. It's hot. It's thick.
Your Honor, if I may, I'll be brief. I want to begin by
It's my
saying
fall shirt.
thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today
I need more
and
shirts
the
like this.
nimbleness that's required
like
to
it.
talk about things like the transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously
Oh,
in the
you
wake
clean
of
houses,
Rizzo.
nice.
It's obviously in the wake of
We are not
Estes.
so
It's here
different
in this state.
from
Unanimous Utah Supreme
where
Court
I come from.
upholding a decision made by Judge McCleve below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told
Thanks,
me
guy.
that he was involved in the shooting, gave me details of
Good
it,
to see
threatened
you.
me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second
Right.
question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea
I
of
think Mr.
sealing a
Novak
document that
lost the
contained
argument.
allegations or details
He lost the argument the moment that he said we don't have a problem with the or we don't have a problem with showing the people in the court. We have a problem with the cameras. When in fact that was a dumb argument for him to make. That destroyed his entire argument completely because it's like, hey, if you're okay with the people in the court seeing it, this is a public hearing. We are supposed to see everything that everyone in that courtroom is seeing. That's a fact. So, yeah, it destroyed Mr. Novak's argument completely.
that were already
I
in the public
absolutely
sphere would
love
only
that.
create the impression that information was being kept from the public when it was not. We stress what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized as a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that
How far
information is
behind are
already in the public sphere.
3 minutes.
That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that middle step is a meaningful one, and if the court were to decide that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing.
Yep.
And they have a
They're
right to
fixing to
be
wait
here,
another year, probably.
and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you are viewing. They want to see the evidence. And we understand you have to balance, but at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it.
I agree.
The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel.
Good argument.
Anything further as it relates
Bit
to
emotional,
exhibits
but
16.1,
good
16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right.
All right,
And
here we go.
Just to be clear, as it
Buckle
relates
up,
to the state's
buckaroo.
request, 16
See
point,
Caitlyn
well,
Jenner drive on
so
the
under the 3 factors, or the 3 levels, admission to the court, publication to the gallery, and then publication beyond the gallery, what is the request for each of these exhibits?
We are asking. We,
All right. Oh. No, please finish your chat.
Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that
Okay,
the
now
witness
speak for
will be
yourself. I
reading
wanna see it.
from portions of the exhibit. But again, we're not asking that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Thank you. The court just wants to. And just for clarification, 16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings? And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing, and it's a factor. So I want to make sure that issue
Huge
has been
factor.
presented by the parties.
If it's in the public, then
If you choose
why are
to.
we even arguing this? You know, it should just be published. That's just an absolute fact. What the heck? My stream's tanked for no reason. What's this about? Just another YouTube glitch thing? No, don't play that. Too loud. YouTube's been glitching out and going weird for some reason. Oh, yeah, no, it's at 170, not at 50.
Your Honor,
You
with
can
respect
be
to
weird.
Exhibit 16.1, some of those text
Oh,
messages
yep,
do
I'm getting
appear on
notifications
pages
that
8
YouTube
and
is having
9.
issues.
Pages 8 and 9 of the
Awesome.
information that is public.
Could you give me a rough estimate or percentage of how much
All
of
right,
the
whatever.
total amount of
We'll deal with that
16.1
today.
appears in that
Get to it.
in the information? Again,
Hooray.
I'm just trying to create a record of what is out there from your perspective, so the court can consider that in its analysis.
Hey, guys, while we're here, please subscribe, like. That brings more people in here. It's the most important thing we can do for the channel. If you guys want to support me, that's mainly what I ask for there. That's the best way to do it. Thank you all so much for being here. I wonder if I could like at all see like how many people are subscribed in this stream versus not. That'd be a cool metric. See stream health. That doesn't help me with anything. Is that really it? Does not give me very good analytics, does it? Huh. Oh well. Yeah, let's see how high we can make this number go today. We got the live count up here. If someone subscribes, it will change this number. Live. I don't have to do anything. It's crazy. It's like a magic trick. Wait. Ooh. Okay, well, something will happen eventually. We'll see it. Boy, this judge, while this judge is being quiet, I could just skip forward a little bit. Ooh. I didn't expect him to be silent for this long. Make him like Beavis and Butthead headbanging.
A photograph.
Did he just
Your
eat
Honor,
that bottle?
Point 1
Okay.
is 18 pages total of photographs
Now we're only
of text messages.
28
It's
seconds
approximately
behind
5.5
everybody else.
Pages of those 18
We'll catch up
pages
here
that
in
are
a few.
reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly.
Nah, Curtis, I'm good.
Anything further from any party?
I think I'll talk when I want to talk. That's great.
defense?
Don't cuss me
To
out.
the prosecution?
That's not a
No,
good
Your
idea.
Honor, thank you.
It's
Media?
a very, very not good idea to do, man.
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen.
We're not
other
even hearing
exhibits, but I
anything,
believe
like,
that at least the
crazy
note
right
itself, which is another one of the exhibits, is also described in the information.
They're not showing any evidence. Nothing new has happened. They're arguing the same
Ms.
thing for the
Kirk's,
same video from
victim
yesterday
representative
that
attorney.
they argued 3 hours for. Let's take a chill pill. Okay?
This has
Little
not been easy,
ridiculous.
as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened.
Like, y'all missing
So-
anything from this?
So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in
Like, nothing has happened in
briefing,
this court at
argument.
all
These are
yet.
important exhibits
Not
as it relates
subscribing?
to
Hey, man. That's great.
what
I'll
should be
help you along
considered,
the way.
For, again,
Let's,
to be clear, these exhibits are being
get
admitted
out.
to the court in its
I
entirety.
do not care, dude.
The question before the court is publication. It's in the courtroom and beyond the courtroom.
Get bent.
And so this is the ruling as it relates to the briefing. And I know it wasn't a formal motion, but I'm just trying to be
think that's
thorough
gonna
in my
change me?
approach.
Oh, I'm going to unsubscribe.
This matter comes
'cause
before
you
the
said
court
a
on the state's
word.
request to publish Exhibit 16.1, 16.2, and 16.3
Again, nothing's even
during the preliminary
happened yet.
hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment.
I don't blame Erica for
Defendant
being upset.
relies
Yeah,
on
they should
Rideau
be.
versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rideau and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rideau because they are written
Now
communications
he's recapping
allegedly
over
made
everything.
outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interest, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rideau, Estes, and Skilling. Unlike the broadcast interrogation in Rideau, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this
There we go.
preliminary hearing,
Finally, some good news. Taking
the
long,
state may
taking long
publish
enough.
Exhibits 16.1,
How many hours does that make now? that they argued this?
16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information, including a phone number and address, to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the
Okay.
ruling of the court.
Good. Why is this?
Counsel, how would we like to
Oh.
proceed?
Just the camera getting choppy, I guess, on their end.
Your Honor,
All
just to
right, here we
clarify
go.
the record, the state has redacted that portion. We anticipated
Okay.
that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have
Hey,
the
thank you, Jenny. I
edited video
appreciate that.
ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right.
All right, I guess we're taking a break.
All right, I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at
And then we'll watch the video, right?
10:50. Court is in a brief recess.
Okay. See, there we go. Yeah, I don't know why that dude got mad. It doesn't even matter. If he's going to come out and start cussing me out and then expect me to just conform to that, it's like, that's not a good thing. That's going to get me to do the opposite. Not a smart idea to do. But anyway, it doesn't even matter. So now we finally, let me tell you all of the things that have happened in court today. They may be allowed to show the video in 15 minutes. That's it. And this is the same video that they argued for 2.5 hours yesterday, in a full hour today. So we're like 3.5, 4 hours in on the same video that they're arguing back and forth on. We have received zero information from the court. Zero information from the court. from the last 2 hours yesterday and the first hour and 35 minutes today. So that's where we're at. Why anybody was even getting mad is mind-blowing to me. So there we go. Now we have a good argument. We had one good argument from the prosecution. One really, really good argument about like, hey, you know, this is all a public court. We shouldn't be treating this any different than if you would have ruled that this was a private court. The fact that Mr. Novak there had a problem, he's like, well, we could post this, just not in front of the cameras. Well, that's not part of the deal. The whole part of the deal is that cameras are in the courtroom. So if the cameras were off and out, that shouldn't be a problem because we ruled that the cameras should be there to view this stuff. Really, really good argument. Really solid argument from that guy, you know? And Mr. Novak really stepped on his own stool there whenever he decided to say, well, I don't have a problem showing the court. The problem is the cameras in the courtroom. Well, that can't be a problem because we ruled that cameras are in the courtroom. There you go. You can't treat the court any differently. This is going to drive me nuts because this camera is showing more ceiling. You couldn't have centered this? Sucks. Whatever. But yeah, that was, Mr. Novak made good arguments yesterday, or what I thought were good arguments until that one guy on the prosecution team, I don't know what his name was, once he ended up making the argument of, Judge, we've ruled that cameras are allowed in the courtroom. What are we doing here? If this was going to be an issue, we should have ruled that cameras can't be in the courtroom. And yeah, I think that's what made the judge rule the way he did, because he's like, yeah, we're gonna show this now, and it's like, heck yeah, that was just a great argument, honestly. Yeah, I got a little bit OCD. It just bothers me. It's like at least don't let this clip out at the bottom. You know, if you're gonna leave this here, you're gonna leave the camera like that. At least kind of get it, you know, show a little bit more. A little better in my opinion. Okay, so who was it yesterday that requested Dirty Deeds Done Dirt Cheap by AC/DC? Who was that? I need to know. Because I was going to do it yesterday before I got off, but I forgot. And, well, how does the song go? Is my phone fully charged yet? It won't charge past 82% for some reason. I don't know what that's about. Whatever, I give up. It's at 82%. It won't die for the day, but I love that I put this on my wireless charger yesterday, set it down, said it was charging, and then like 2 minutes later, I guess, it just stopped. It's like, oh, that's awesome. Thanks, guys. New technology is garbage. I need to get me a flip phone and then buy me an old school MP3 player. I'll be good after that. I'm going to get rid of this garbage. I'm so sick of it. It breaks, like this new technology breaks like after 5 seconds. And so it's like, yeah, that just sucks. Wait. 7:38? What's going on out front? What we got going? Oh, that's because my phone was off for the whole time, and now it's showing. Okay, never mind. That's just me getting home. What just happened to the camera? Did they throw a rag over it? Oh, they were showing the ceiling. They doing okay? Are they watching my... There you go. Stop. You're good. You don't have... Okay, or center it a little bit. Hey, yeah, there we go. Someone's watching my stream. That'd be so funny if the... Hey, camera guy, if you're watching my stream, stick a thumb right in front of your... in front of the camera. Wouldn't that be crazy? Wouldn't that be crazy? If he does it, I'll absolutely lose it on stream. If he does that. Love your flip. Yeah, I mean, I got the fold. I love it. I'm gonna get the tri-fold, but I'm just hoping that these things don't break because I've done nothing to this. I treat this phone with absolute respect. Like, look at this. Like, you know, it. Let me get the fingerprints off. Look at this thing. It shouldn't be breaking. Okay, look at that. Does this look like I damaged my phone? Like, it's crazy. They should not be this sensitive. Like, the charging port should be fine. Like, this phone's only like a year old. Now, keep in mind, this is the Fold 5. You know, I don't have the newest Fold by any means. What are they at now? They're coming out with the Fold 8 in, like, 1 month. Yeah, it should drop in August. The Fold 8 should come out, I think. Let me see. When does Fold 8 come out? Oh, shoot. It's coming out July 22nd. Never mind. So, yeah, I'm like 3 phones behind. But, of course, they make them garbage, and they make them break over time with very minimal use, so you upgrade. And I'm sick and tired of it. I don't want to upgrade. My phone is fine. My Fold 3 was way better than this Fold 5. By a long shot. Remember the Razor Flip? I remember the original Razor. Was it? Oh, you mean just the Razor Flip phone? Oh, yeah. Yeah, KBX, you know what's up. Yeah. I always wanted one of those. I never got a Razor myself. But I always wanted a Razor. I ended up having a garbage Samsung pull-down phone that was my dad's. Actually, every single phone I had was my dad's until I turned 19. I got my first phone by myself that I got to pick out, and it was the iPhone 3GS. After that, never went back to iPhone again. See, back then, the reason why I stopped iPhone is because I jailbroke my iPhone and I gave it an Android GUI. So, got a Android GUI on my iPhone. Ended up getting all my custom ringtones and everything. Apple stopped that with the iPhone 4, and I was like, well, I'm just getting Android then. And then I've been on Android ever since. I think I got the Android, what was it? The 5. The Android, whatever the Android 5 was. It was the Android Galaxy 5. And then after that, I upgraded to the Android Galaxy 7 Fold, the 7 Active. Y'all remember those? That was a great phone. Probably the best phone I ever owned. Are you familiar with the solo in Megadeth's My Last Words? I want to say it's the last song in Peace Sells. You mean a Tout Le Monde? Peace Sells, is that a Tout Le Monde? Peace Sells, but buying. Okay, Discogs. Oh no, it is just My Last Word. You're right. My Last Word. Okay, so My Last Word, Good Morning and Black Friday it's probably the best song on that album right there. That's some Marty Friedman crazy solo stuff. I don't know the full album. I guess I've never listened to My Last Words. I just remember that these are the last words I'll ever speak, and they'll set me free. That whole thing, except, obviously his voice. His voice is hilarious. Great stuff. Great stuff. Yeah, the Galaxy S7, easily the greatest phone probably ever that I had. Oh man, so good. S7 Active. And that's gone. That's gone now. You should check out that solo. Yeah, I'll look at it. My Last Words. Let's see. My Last Words solo. Let's. Okay. Let's do it. Already, Dirty Deeds Done Cheap was you. Oh, it was you. Let's do it real quick. Okay, hold on. Let me do this, Dirty Deeds. Let me get the rhythm real quick. I'll do the intro here. Deeds Done Cheap. Let me, Okay, so it's, okay, gotcha. I think. All right, here we go. How's that? I added a little bit of in between notes, but it's just I think that's it, right? That's Dirty Deeds. And then I think that's all. I think that's pretty much all of it. I think it just repeats the whole time, right? Doo doo. And it gets to this part of the verse. Okay, that's gonna play the real song. Let's do synth. Oh wait, that's the synth? That's gonna sound way too much like the song. I'll get copyright stricken for that. What's the chorus? Na 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 na. So it's just then they hold that note forever. Then yeah, okay. All right. Yeah. No, that's good. That's a good classic song. That's with Brian what album is this from? This is old AC/DC, isn't it? That doesn't sound like what's his name? I can't remember all the people's name. Is it? It's not Bon Scott singing, right? It's who's Brian? Oh man. Oh, it was Bon Scott that wrote. Okay. So Brian Johnson's the new. I keep flipping Brian Johnson and Bon Scott. Yeah, Bon Scott was the guy who did the original song on that. Okay, good. So you like some old school AC/DC. Heck yeah. Not that I don't like Brian Johnson. Back in Black is a iconic album, you know. Probably their most well-known album, so obviously he's a good vocalist. But I do prefer Bon Scott. He's much... How would I put it? He's much more versatile, I would say. He's a much more versatile vocalist. Just in general, in my opinion, I don't think Brian Johnson could be in any other band other than AC/DC. You know what I'm saying? Like, once they kind of, because that's like the AC/DC sound, in my opinion, is Brian Johnson. But if you were to put Brian Johnson in a different band, he couldn't do it. Bon Scott, he could go to any other band. He could adjust. He has a better vocal range. And as a musician, I appreciate that more than the band having their very hardcore original sound, in a sense. If that makes sense. You know what I mean? Most people would hard disagree with me, which is fine, you know. But as a musician, I look for versatility, different styles, and different things that people can do because I appreciate that and look up to that specifically. When most people who are not musicians or more of a layman's musician, like they, know how to play a few things and enjoy what they play, they're going to definitely like the band's actual sound. I don't care if a band has a sound or not. That's not my thing. I've never worried about a band having a specific sound, if that makes sense. A lot of people care about that. I do not. I care about if they can make really good music and what they can voice that music to reflect what it is they're doing. That's what I mainly care about. You know what I mean? But yeah, old school AC/DC, in my opinion, I like it more. I really like it. But of course, I love Back in Black. It's a great album. There's nothing wrong with that album. Am I in a band? Technically, kind of. I'm in a band, I guess you could say. You guys know who Bearing is? Now, we haven't done anything yet, and we might not do anything. I don't know. You know what I mean? But he has formally invited me to be in his band. Also an Australian band. All right, let's check out this solo. So it's doing a little string skipping. Nice. Oh, that's a little. Okay. So, oh, wait a minute. I'm dumb. It sounds like that's part of the solo sounds awfully a lot an awful lot like obviously this was way before, but da-na-na-na, that dramatic music during the Goku Black Art. But they add a little extra note. Okay. Okay, so. Oh. Da-na-na. Oh, but he goes down. He doesn't go. He goes. Much easier. Oh, you can't see my hand. So I was going. Like that. But really what he does is.
We'll
like
wait
that.
a moment for the public to be able to.
Oh, they're back a little. They're back on
come back into the
time.
courtroom.
Hey, look at that. So it's okay, so it's going to repeat that a lot. Is it go back up to 7? Okay, so it does. Okay, let's try that again now. I kind of got it memorized. Okay. Oh, I did it wrong. Okay, I like it. Yep. We'll get that part memorized here. Oh, that's too loud. I'm sorry, guys. That is way too loud. Do I have a volume control on this at all? Actually, I think I can't believe they went back. I thought recess was what's happening here. Okay. Signal RGB. Why does that even have a volume? That's dumb. Do I not get any of this over here at all? Okay. I can't even select this by itself. Why? Give me the option. Okay, I'll get this figured out. Do I get a mix? Ah, I do got a mix. Okay, cool. There we go. I knew that there had to be one in here. Okay, so I could kind of just to test it out. We'll get it here. That's not what the tabs say to do. It's a oh, there's a double repeat. Oh, I didn't see that bar. Okay, so it just. And then he moves on. Okay. All right, we got it. Heck yeah. All right, we're good. Play the video or no. The video's live. I promise. Video's live. I haven't stopped playing it. Okay. Genesis was a massive group. You'll find a million things. Oh, yeah. Genesis is great. That's, Tarzan guy there. What? And why can't I think of his name? Oh. Okay, so
Back
okay.
in session. Welcome back. Turning to the state.
Is it that or that?
I apologize,
Just noted
Judge.
this
We were
stuff.
having computer technology issues, and we believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right. Well, how much time do you need?
Just as long as it takes to show the video, so maybe 10 minutes.
All right.
Think it-
Well, we'll go into.
Phil Collins, that's right.
Well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize
I've never
that
played it before.
we
So
were at this point.
Don't hate.
We'll be in recess for
that was just all off
10 more
memory
minutes,
from just humming the notes
so
in my
by
head.
11:05 approximately.
I'll get to that solo some. I'll try to learn it fast.
That should work.
Once
and
we get
also
on the
can
next,
inform the behalf
break.
As soon as we're done, if it's ahead of that time.
All right. So, ladies and gentlemen, I apologize. I thought we were ready to proceed. I want to be respectful of everyone's time, but all at the same time keep this
Your camera's a little
hearing moving
twisted
forward.
here.
So,
Should
court is in a
should I
brief
sit like
recess.
this? We got some more time to learn this solo. All right. All right. What do we got here? So then it goes from that part. Okay. I think it's either that or they're all in the same key. I just can't remember which one's right. So we'll figure it out. Yeah, they've had a lot of time to figure this out. I don't know why. This has not been a great experience. I can tell you that. They have bungled a lot of arguments here and a lot of rulings for no freaking reason. Here's the thing. The defense has had ample time to have their issues heard before all of this took place. They've had ample time to get these arguments to the court before we actually proceeded with this preliminary hearing. They have failed many, many times. And here's the problem. I actually ended up having a problem with a ruling in my favor back in the day whenever I sued my old landlord because a judge kept allowing the defendant to get their crap together when they should have had it together months before we even started our hearing. Now, it still went in my favor, but it's getting ridiculous. It's getting ridiculous. This judge is allowing the defense to... How would I put it? The judge is giving the defense too much leeway for things they should have had done a long time ago. And I'm getting really kind of tired of it. The judge is showing way too much leniency at this point. He should straight up tell these people, okay, too bad now. We have to move forward. Time is not on our side now. This is the last day of the hearing. And yet we're still screwing around with something that should have been resolved when we heard this yesterday. And it should have been resolved before that. It's really, 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 really stupid. And it's a waste of everybody's time. So anyway, Ashley B for the $20. Thank you so much for that, Ashley. Thank you. Yeah, he's letting them manage the time clock. It's getting a little out of control in this courtroom. Hopefully they're back soon. And we get this ruling I thought the ruling was kind of absolute. Like, they took a break, and now his own, like, this judge has ruled several times on this. He's already ruled. Why are we still hearing arguments? It's like the judge is kind of losing control of his own courtroom. And he's not doing anything to regain control. So there is that. It's just a little bit irritating. Yeah, only 10 or 15 minute break. We are now at, when did we take the break the first time? How many minutes ago was that? That was 26 minutes ago. 26 minutes, 20 seconds ago is when we took the break. A 15-minute break. Very frustrating. Okay, so. Okay. Then, okay, so we get the oh, I hit pause. Did I pause this? No. Wait, did I? No. Okay. All still alive. I want to make sure I didn't do that. Okay, back to here, so it would be. Okay, that should be pretty straightforward. So. All right, that's going to be a pain in the butt to memorize for a second. So, all right. So I'm going to start my finger here on the root N. Maybe it'd be that motion. So I want to go to this motion here. So we go do, 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 do. There you got to stretch. So it goes from this, and then we're introducing a sharp, and then we're going to go right here. Bigger stretch there. Yeah, that's a little jarring in that, but once it's played fast, it won't sound as dissonant. Okay, where am I at? So I hit the first 8, and then it drops down to 8. And it resolves right there. Okay. So. That down there. Did I hit the right note? No, I didn't. No, it goes. Okay, so that's gonna suck. That part's gonna trip me up bad for a little bit. All right. We'll be able to get this, guys. We'll get this. Yeah. Yeah, it's for the victims. Yeah, I agree. Oh, Candace is crashing out without a doubt. Man, are we gonna get back to the court? I cannot believe it's taking this long over this stupid video. Can we please just see the video? Most of it's public anyway. And they're wasting our time with this. I'm getting actually pretty irritated, to be honest with that. And it drops from... Wait, do I go up to the 10? Yeah, I go up to the 10. Then I drop down to the 8. Oh, yeah. Getting them spider chords. Okay, I'll get this memorized here in a second. So I'll work on this first. Okay, no, I won't. I already got it. Never mind. That's funny. So. Okay, then I got to drop from there. That's how you do it. You just got to memorize it. I keep thinking that I'm not supposed to hit that, and I am. So that's why it's doing a double. Oh, I know, I'm good. I keep doing that. Okay, this stream's coming back soon, I promise. Eventually, this judge will come back. Okay, just to make sure we're not any seconds behind, right? Nope. Nope, it's all live. Dang it, this sucks. Well. Okay, so. Okay, so we got. Then from the 8, I drop down. No, from the 8, I go up to the 10. No, I don't. Okay, so. All right, let's make sure I got this now. So it's definitely. Okay, I'm messing that part up. Did I hit that? Okay, so it is just. Okay. Okay, I'm getting it there. It's pretty much there. Pretty much there. Pretty much there. All right, I'm getting there. I'm getting there. I'm getting there. Getting a little bit better. This will all make sense in a second. Sorry, guys. It'll all make sense in a second. Kind of. Ah. Okay. Calibrate here. Think. Relax. And. I keep wanting to follow the pattern. He breaks that pattern at the end. That makes it a little difficult. And I hit the pattern again. There we go. Why do you come up with the weirdest crap? Aylin. Or Q. Call you Quacky. How about that? On stream, you'll be known as Quacky even on stream. How would you like that? I got some power here. Yeah, no, so they wear dead fishes hats. Oh, that's great. Good for them. They definite savages there. Does it keep their heads warm? One of the greatest guitarists, actually, the first great guitarist was Jimi Hendrix, and the second one was Eddie Van Halen. Oh, I would definitely put Eddie Van Halen leagues above Jimi Hendrix. There's a lot of misconception with Jimi Hendrix's skill. Jimi Hendrix wasn't what I would call a skilled guitarist. I would call him a skilled musician. Jimi Hendrix, when he passed away, he only had been playing guitar for 2 years, I believe. That's what made him a prodigy, because he learned so much in that short amount of time. But his skill level was still only developed up to as much as you could learn in 2 years. Long. I think it was. It says Jimi Hendrix played the guitar for approximately 12 to 13 years, but I don't think he really learned how to. Didn't really learn how to play it early on, like people would think. Let me see. How many albums? What timeline? He released like 7 albums in a year, was it? No, it was 4 albums. And he did it from 1967 to 1970. Okay, so he released 4 albums over the course of 3 years. And then I believe he had 2 or 3 more albums that were never really released.
Court is
or
back
something
in
like
session, noting the presence of the parties.
I think it
all
was.
being present. And where we left off is we were.
But he wasn't like
the state was looking to confer with defense to ensure that
He
state
was so good
exhibits
at making music.
16,
He was so good at
16.1,
making
16.2, and 16.3.
But a lot of people think that he
were
had
shared.
immense
Ms. Hunt.
guitar skills.
We have reviewed Exhibit 16 with defense, and it comports with the court's order.
And he did. He did have
At this
immense
point, we would
guitar
like to
skills,
put Agent
not-
Davis back on the stand and continue with displaying that.
I don't know why
publishing
people
that.
look at Jimi Hendrix as a
Agent
guitarist
Davis, if you'd like
first,
to
though.
come forward. I
'Cause he
remind
was
you, you're
clearly
still
like
under
an
oath.
all-around
Like, have a
musician.
seat.
And he didn't just go out
There
and
should
play
be a water
guitar all
bottle
by
to your
himself,
left,
and that was
and
it.
after you're situated, if you wouldn't mind adjusting that microphone
I think
and bringing
people
it
do
close to
Jimmy
you,
disservice
so the
by
record can
ignoring
pick
that
up
part,
your
to be honest.
testimony. Ms. Hunt, your witness.
And just for
All right, we're finally back.
the record and the
Oh,
court's
Stevie
benefit,
Ray Vaughan, he's
we
insane.
have made the edits
Insane
that the
guitar
court
player.
has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected
just
very
to add a
clearly. So
caveat.
there are sometimes large.
Just real quick. Had Jimi Hendrix not passed away, I have no doubt he probably would have ended up being one of the greatest guitarists alive today. Just pointing that out there. He just didn't have enough
large
time.
gaps of just
you know?
black, empty, silent space.
All right, what are these arguments
When
we're
there are
hearing?
large gaps, we will fast forward. Some of those are short enough that we'll just let it play, if the court is okay with that, with proceeding that way.
Thank you. I appreciate
Hey,
giving
thank you,
heads up
Rachel.
so all parties know what's going on. Thank you, Ms. Hunt.
All right,
So
here
at
we go.
this time, we would move to publish on the monitors State's Exhibit 16.
All right, and to the media, there is a monitor for your benefit right there next to you. For the camera, there is one for that direction as well as for the gallery.
Lance Twiggs meeting. Here we go, finally. Got everything good. We're watching this video now.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. Understand that? Mm-hmm. Okay, so In order to do that, I need to place you under oath and also give you an admonition about false statements, okay? First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination.
I'll answer that question in a second,
you
Jenny.
make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. You understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that?
Mm-hmm.
Okay. First, we're going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of
You
Charlie
had to think
Kirk.
about that one.
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
Where?
Will you describe your relationship with Tyler when you first met him anyway?
When I first met him, I didn't know him super well. He was just a new roommate, so I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on, your microphone?
No,
Okay. I'm going to repeat those admonitions just to make sure we got it recorded.
Oh, the audio's
Okay,
completely
so,
doubled.
Again, I place you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
It's not me. It's on there.
Going to give you the false
I can hear the echo badly
Sorry,
too.
hold on. If they're saying that it's echoing, so.
There we
I
go.
think this one's mic
They
is
figured
on.
it out.
Okay, sorry.
Okay, you know I'll mute my mic. That's fine.
Okay.
Okay, so we should be good. All right. Is that mic on?
Yes.
Okay, great.
Sorry.
All right, okay, sorry about that interruption. All right, so you said when you first met you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates, is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
Bro,
And
spit
is
the
that
gum
apartment
out.
the same place you lived when
I said
on
gum.
September 10th?
Yes.
With a G. Okay.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was
probably
his typical work day like?
If I had to guess.
I think he'd leave around 7 generally and get back around 3 to 4, depending on where the job was and how long it was for the day. And then on certain days of the week during school, semesters, he would then later in the day, I think around 5 or 6, go to school. So, yeah.
Okay, let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Into September. Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna have him spit out his gum just to make sure that
I can do that.
you're lying
There you go.
right in front of your laptop.
Yeah, I'm not
There you
crazy.
go.
Thank you.
Yeah, nice job being disrespectful. Ridiculous.
Thank you.
All right, so what time did you get up on September 10th?
Yeah,
Probably
this-
like
this is last
12
week.
to 1 p.m.
You didn't have to work that day.
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.
Yeah.
Okay. That's how they decided to redact it. They didn't splice the video. Okay.
What about
These guys have the video
he
editing
asked you
skills.
here, remember how I was engraving bullets? Was he
I'm a
engraving
third
bullets
grader.
before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where our Dremel was and told him to make sure he doesn't set off a bullet on accident in the house. But I didn't really think about it until then.
How long before?
Yeah, that's normal. That's normal.
September.
Yeah, I'm going to go hunting. Let me engrave some of the bullets for whenever I get my deer. Because the deer's going to give a crap about that, right? What? I think Lance Twiggs is being a little obtuse here and pretending like he doesn't know some information. That's my opinion. I don't have proof of that, but that's a little ridiculous.
10th was this that he asked about the Dremel?
I don't remember because he'd been talking about the hunting/camping trip for a couple months, but I don't remember when he was specifically asking to engrave the bullets. So
are we talking like a year before?
Oh no, not that long. It would have been I'd say at most a month before this was when he was asking.
Okay.
Yeah.
Okay.
I hope we can get some information as to
Right.
what
you talked
bullet
about
this
the
is.
note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay.
So where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th,
Yes.
the night of September 10th.
Mm-hmm.
Right? And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And now I want to go to what's been titled 16.2. And do you recognize this series of messages here?
Yeah, that was the server of like his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And
Oh, there were no Discord messages. Ha ha ha. Anyway, they took out the video part here because that's what they agreed to in the ruling. So they're not showing because they don't want to show the text messages in the video to the public, I guess. Even though they're all public, but okay, whatever.
who are members of this server? I don't want names, just generally. Who are these people? Who are members of
This is his friend group. They played D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look at it. Go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
Yes.
Yeah, like DM means Dungeon Master. So this is these are like most of them are names they're using in the game they're playing currently.
Got it.
Okay. Oh, DM was Dungeon Master. Gotcha. Okay.
Yeah, it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
Oh, no way. His last text was from 8
that
p.m.
would be the 11th.
Crazy.
On at least I think so, because I don't think on the 10th that he messaged anyone before me at like 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
Okay. So again, we're just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
To my knowledge, yes.
And that was sent, looks like between September 10th and September 12th. Looks like the last day on this is September 12th. Screen?
Yes.
8 p.m. text says is the one that Coleman says is fake. Yeah. Coleman's got some explaining to do.
Okay.
Oh, we're back. We were back to having video. Cool.
All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting.
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home, and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
Okay. Is that them redacting the address? I have to adjust the camera at all. The camera was fine. Doing.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it, and then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
Okay.
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay. Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat,
Okay.
but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images.
Exactly, Dent. Oh, and to answer your question earlier, Jenny, yes, Prince is an insanely
I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do
you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans, so.
He changed his hat, too.
It definitely, especially the bottom, the last 2, definitely do look like him.
There you go.
Oh, they do look like Tyler Robinson.
Let's have Candace Owens called Lance Twiggs a liar.
You talked about that with your friends, right?
His own boyfriend. Let's see her call him a liar.
Yeah, I don't know if I talked. I don't remember if I talked about it with any of my friends.
Call him a liar.
And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
We played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some like shooting games together, but I didn't know him very well, so that was just when we had like a whole friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did he ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
Well, more redacted stuff. That's fun. Oh, what did YouTube do? Sorry, I missed it.
Okay, so before that you have been.
For a short time, yes.
Okay. And I understand you're going by
subscribe. Let's
Luna
make
at
this
some
number
point.
go up.
To some
you, guys.
people, yeah, but not as an overall thing.
Okay, these redactions are getting annoying. This is really getting annoying. Wow. Guys, edit the video. Just cleanly cut it. It's not hard. It takes like 10 minutes.
Okay. Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything. The Dremel that you talked about, you said he had asked for that, is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
What? Name them.
So did you have a Dremel then?
Yeah.
Okay.
It was in our, like, our apartment, we had a section where we kept all our, like, random tools for household stuff, in our, like, lower basement level pantry. So, yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was, yeah.
Okay, I'm going to go ahead and end the recording for the 1102 purposes.
All right. I was really hoping that they'd be like, do you know what he specifically, what bullet did he engrave it on? That would have been an awesome question.
All right, that concludes State's Exhibit
we didn't
16.
get that.
Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from
anything's possible.
Court-ordered redactions, did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
Wait, really? The evidence list, we will... are you saying, Grits, that we will see the bullets entirety in this court case?
I see it. I see it now.
Do you recognize
We can figure out exactly what
Yes,
rounds
I
were
do.
fired
What
off.
is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Sorry.
Our post case can't
these are
move forward?
photographs directly
Probably
from
because
Lance's
they're
phone.
lacking something. They'll
How
get
do
it
you know
figured
that?
out, I'm sure.
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at
Wait, who
a
got kicked off?
picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
Oh, a judge recusing it. So if a judge recused himself in the Brian Harpole case, let me get this out there real quick. That probably means that there was a bit of a conflict of interest. So it's probably going to a different judge. The judge probably either knew Brian Harpole or knew Candace Owens, had a little bit of a conflict of interest of some sort, or was friends with somebody's attorney. And so the judge recused himself. That means that they're getting another judge, more than likely.
You kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah,
I'll
during that
take a
first
look at
interview
that.
on September 12th, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview, he refers to the large crack in the upper left screen. So he identifies that in his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit States Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court, of course, is very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of States Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m., will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize, let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also
Notice how there's
acknowledges
always
that,
dates.
who was saying what.
And up
Notice
at the
that?
top,
Candace?
who do we see that this thread is between?
Tyler.
Pointing that out there.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
If we could scroll down to page 2.
You didn't have to say the F word, but all right.
And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem
Hey,
for
Candace,
a little while longer yet.
are these fake?
Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
They turned the
You
camera.
could scroll down to page 3. Continue reading.
Lance says, why?
Okay.
And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
This is while they were spot, but I don't want to chance it while they were parked there. If they'd found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4, so just scroll down 1, please, Kimberly. And if you could read starting, sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. Will
Sorry, now we're on page 6. Continue reading.
we'll update soon. He continues, the squad car was moved further away, enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud. Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if it had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8. And if you could start at the top.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
And let me stop you there. And then if we could go
Right on that word, not
to the
before.
next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15.
Oh, this is wild. I wonder how Candace is going to deny all this. You know?
And then the second grade message.
Nah, rabbits. Tyler
on
could walk up
page
to
15,
Candace
if
and
you
admit
could start
everything,
there.
and she'd still say he's lying.
Okay.
That's
So
what
this is
happened.
Tyler. I'm going to turn myself in willingly.
I'm not even
One of my
kidding.
neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Oh, you meant Tyler.
And we
Gotcha,
can
gotcha.
remove,
Oh, yeah. Yeah, we're on the same page.
The
That
exhibit
makes
from the
sense.
screen. Thank you, Kimberly.
These text messages are
We
it,
mentioned
like,
a Cellbrite extraction in Mr. Twig's phone.
I wanna
Do you
know
know
what-
what
how
time
Candace is gonna
that
react.
last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th make sense? Or you're saying September 11th?
So September 11th was when he turned himself in. That would have
Okay.
been September 11th. Yeah.
Okay, thank you.
Yep. Yep.
All right, I'm going to show just for the witness, State's Exhibit 16.2. Let me know when you see that.
Okay, I see it.
Do you recognize this?
I do. Yep.
What is it?
This is just more photos of Lance's phone. And
How
these
do you-
are these are the
Thank you, Val's.
sorry, how to bring
Val's view?
sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
And what is it of?
These are the Discord messages of that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit, 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He
not using the right
identifies
terminology,
that in his first interview with the two FBI agents, and then he again confirms that in the second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate?
Did y'all hear the name he just said? Did y'all hear that name? Yeah, I did.
IKUM. Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Wow.
Did law enforcement send, as part of your
Good try
investigation, did law
on
enforcement send a
pronouncing that.
subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in State's Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
Mochi Mom got it. She figured out what he was saying.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Admit it.
Mr. Novak.
Thank you, Aaron. We've
Hey,
already
Frankie,
lodged
thank you
all
for
of our
that $20
objections on all three
donation.
phases.
All right. Noting
You
the
left no
objections.
message. Last two people left no
Standing
message.
objections by defense. State's
But thank you
Exhibit
so much.
16.2 is admitted into evidence and may
There we
be
go.
published only in the gallery, not for distribution on electronic media.
What is this evidence then? This better not be the bullet casings. I want to see them. I really want to see them. But they're muted? Okay. Why is this muted? This isn't good. Is this what he meant by it can't be, like, submitted, so they muted their microphones? Or they muted the camera audio? That sucks. Has other users on there. Yeah, but their usernames are just usernames. Wouldn't be anything personal, so I don't know. Not to mention they named everybody a part of the thread on their silly usernames. The Dungeon Master and all that, so I don't know. Cracked my knuckle. You need to give me one of these chairs right here. That'd be great. Something like that. Yeah, but they already gave the names. That's kind of the point. Like, I don't know why they would give the Discord names away, and then they would redact this because of Discord names. See above? This is the Discord message. Wait. You can see above. Oh, you were talking about, okay, you were talking about my sister's comments here. Hey, he doesn't blink very much, does he? I'm going to try and outlast him here.
I see it.
Do you
I'll go
recognize
back now.
this?
I do.
What is this?
God,
This
he blinked.
is a
Now he
handwritten
blinked again.
note or
Okay.
letter
Now I can blink.
from Tyler to Lance.
How do you know that?
That sucked.
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this. This is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twiggs gets a text from Mr. Robinson around 11 p.m.
So the Masked Mother asks, honestly, do you guys think Candace will stop with the BS after all of this is over, or will she dig herself into a deeper hole? Honest answers. Honestly, well, this is just the preliminary hearing. She's not going to stop. She's already digging herself deeper and deeper and deeper. She's already posted something so profoundly stupid, it's irritating. And I'll show you guys here in a little bit. But it's really not going to be good. Candace is going to keep this going for another 6 months to another year until the trial happens. Then I think she's going to dig herself into a deeper hole during that entire time. Once the trial happens, it's going to blow up in her face, I think. That's my prediction, but we'll see what happens.
On September 10th, telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard.
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was
Hey, KBX,
located.
you have a good night, man? Thank you for being here.
I'm going to break down a few things. You mentioned I just want to make sure the record's clear. You mentioned Celebrate a few times. What is Celebrate?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data, to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. It's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Celebrate phone extractions. Have you spoken to the law enforcement officers that performed the Celebrate extraction on Mr. Twig's phone in this case?
I don't believe I specifically talked to those individuals, the RCFL, that did that. But they, yeah, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I have spoken with an SIAC analyst who in particular found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twiggs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3, correct?
Correct.
Is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
All right, here we go again. Kind of sucks, but whatever. It is what it is. Let's see. So what do we have? Hey, Binky, what were you going on about, man? I'm really curious. Like, what was that? We're not even talking about black people in here. Like, I'm so confused as to what you're talking about. You're saying they lying. False flag lying MFs. What? Like, who? Who? What? What are you talking about, dude? Well, I'm smelling some chemicals. Like lavender. And that's strong. Wife is cleaning something up fierce. I think she's overusing chemicals, to be honest. I should not be able to smell that in here. Unless she's cleaning, like, right below the turn air or something like that. It's probably coming from my air conditioner. It smells good, but, man, it's strong. I'm not sure what you're talking about, Binky. I'm just confused, man. Like, we just can't say the N-word in chat, you know what I mean? I can't allow that. So as long as we just don't do that, man, we're good. We're good. Okay. You know. But I just don't know. Everything S your mouth? What? I don't know what you're talking about, dude. I just want you to clarify. I'm not getting on to you. I'm just saying don't say the N-word, you know? I just want to know what you mean, though. We had other... What was the other stuff here? So...
I do.
What is it?
These are the images that the FBI released to the public. It would have been on September 11th when those were released. And this was, those were those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does State's Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections, thank you.
All right. Noting the standing objection by defense, overruling that objection, State's Exhibit 16.4 is admitted into evidence and may be published in the courtroom.
And again, in the Discord,
Being quiet again. Well, while we're here, so let me go ahead and I'll pull this up real quick. Let's see. So Candace Owens decided to sneak this little thing in here. She's like, "Oh, looks like we have another paver emergency. Going to need to dig out and re-cement the wall or something to make the height work." Ha ha ha. Candace, I can't even see where you're measuring. There's like multiple holes. For all I know, like this hole right here is apparently at like just right above it would be. That wouldn't make sense at all. If this is 5'10", that would make this dude like 7 feet tall. That'd be like a 7 foot tall dude. Sorry, Candace. No chance that a 5'10" guy is coming up to this dude's chest. Okay, so just the difference from my chest to my head. Okay, right here, from my chest to my head would be how tall is that? It's got to be like 10 inches, I would think. 14 inches. 14 inches from chest to head. Okay, so 14 inches. Top of the head here, down to my chest, where this would very clearly be right here. So you're telling me that this dude is 14 inches taller than 5'10". That'd be 6'10" plus 4 more inches. That'd be 7'2". Did I do that math wrong? That's what Candace Owens would have you believe. Like, that is insane. That's actually insane. Candace Owens is a moron. Absolute moron. Like, hold on. If man, this is getting cut out a lot. Oh, not that. No. Anyone else? Tag. That's. No, wait. I need Bronson. This. I need There we go. Wait a minute. Oh my God! I just caught Candace Owens. Actually. Wait a minute. I just caught her. I caught her. I've already got her caught. Check it out. There's absolutely no creases here between these dots, but there's a long crease right here. Where's this crease? Where's his headline up? Right here with this crease. Unbelievable. Candace Owens is actually an idiot. Hold on. Don't worry, the sound's on. The sound is on. If the court, when the court gets its sound back, we will hear it. You know what? Let's. I'll minimize this. Well, eventually we'll get sound back.
As it relates to 5.1, the court previously, the day that I did it, I believe it's day 2, perhaps.
That sounds correct.
The court provisionally admitted it, contingent on additional foundation being laid, whether through testimony or through evidence. And the court notes that such foundation and testimony has been laid in order for the foundation to be laid for 5.1 to be admitted into evidence for full consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense that this is going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotates.
Thank you all so much for making that go up.
76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression, and that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant whether how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and is not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so,
All right.
if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Let's
Thank
see
you.
it.
Yes, we do. And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you.
A little hard to see here. I wish they could, like, screen capture. Come on, you had it for a little bit. I can't read any of this, guys. Please adjust that just a little bit more. Like, just turn the brightness down slightly and you'll be able to see it. Like, just a little bit, please. No? I can't read any of this. I cannot read any of this at all. Great. All right. Notary acknowledgement, 28th of May for something. Are these documents public at all? Am I able to pull these up?
All right, I believe that should be sufficient. And Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twiggs. Kimberly, if you could turn to page 17.
Yeah, I have no idea what we just saw, to be honest.
And because this has already been admitted.
Oh, that's the David Englehart.
And
Okay. Yeah.
Court, correct
So
me if
that's what
I'm
they were
wrong,
arguing over
published
yesterday. Okay.
not only to the gallery, but
testimony.
to cameras at large. I'd ask that it be displayed in that fashion again.
All right.
Gotcha.
Any input
So-
from any other party?
This was
on
his
that request?
testimony, David Englehart's
All right, thank you. That may be
testimony
published. And
to show
you
Tyler
can look
Robinson
this up as
attacked with political motivation.
Agent Davis, if I can direct you to the very last message on that page, starting with "if any," if you could read that out loud.
Okay.
Okay.
That's pretty
This is
straightforward. I just
Tyler.
wish I
He
could
says,
have
if
read
any
it.
police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, so
Okay,
they're
thank you.
private.
That-
I can't show
that's
those
all I need
documents.
from
Well,
that
that
exhibit.
sucks. I would have liked to have read
And
it
then
out loud on
finally,
the
Agent
channel.
Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there.
Yes.
Oh, Bonnie Tyler passed away today?
You stated that you transported or assisted transporting him up
Wow.
to Utah County Jail,
Yes.
and that
He
you were
was
the
old,
booking
though,
officer.
right?
That's correct.
Be in her 90s.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's the individual seated at the defendant's
yesterday,
table
okay.
in the center chair with a
She
gray
was
suit coat
75.
and a green tie.
Younger than I thought.
Your Honor, if record could reflect identification of the defendant.
counsel?
Okay.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness, thank you. And I don't know if now would be a good time for lunch.
All right. We'll go ahead and break right now for lunch for 1 hour, well, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up with defense for cross-examination if they choose.
They're going to
for
take an
Agent Davis.
hour?
Does either party need the benefit of the
Woo.
record before we go on our lunch break?
Not the state.
No cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination. May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next witness. Court is now in recess.
All right. So it looks like we're going to be chilling out for an hour, guys. So yell down for that. I may have to get myself a couple things of food or something. Let's see. So I will be right back. I'll come back up here. We'll do some guitar stuff for a little bit while we wait on them to come back. And they say it's an hour and 5 minutes they'll be back. It's going to be like probably an hour and 30 minutes, but we'll see what happens. They're just eating lunch. They're not litigating anything, so there's no reason for them to not be on time. Let's see how this did. So I'm going to show you guys what I did real quick, too, before I go and just kind of grab some quick foods. So, nope, that's the fake tweets. I have no doubt that she faked these tweets. It just doesn't make sense. Considering cellular, Wi-Fi, and battery indicator don't seem to be as aligned as they should be, yes, probably. Oh, wait, really? They seemed decently aligned to me. I don't know about that. I don't know if that's what I would look for. Let's see. I just tried to take you seriously, and if you don't think Charlie used to cuss, you're kind of weird. He's not Jesus. Then show me proof. That's just so dumb. That's so dumb. Like, Charlie Kirk never cussed. Like, he never, like, there's no evidence of this at all. This is the first time we ever see a text of him, like, cussing, and then it's like, nah, you know. Funny, that's the threat of text from Andrew had dates and times, but from Charlie there was none. Right? Say that was Charlie. It would have been from a very long time ago before Charlie really got to know Ben. To be honest, I don't know when it would have been from, because there's no date. Your name is fitting, troll. Prove he would have said that. Like, I mean, it's just so easy. These people are dumb. They're just dumb. They're really, really, really dumb. They don't question anything at all. Anyway, for this, where did I make it? So I made this. Here's the thing. Here's that line. I highlighted the line. This is the line. It shows right here. 7, let me go to Candace Owens. I think it was a lot easier to see on hers. Maybe. Oh, what's this? 7 minutes ago. Hello to everyone who is just beginning to pay attention to this trial. Some of us have been reading and covering the extensive court filings for months leading up to this hearing, and we therefore already knew this offensive hearsay video from Lance Twiggs was going to be played today. Okay. None of this is shocking or new to people who can read. The whole point is that it exists, Candace. They showed that it existed. And you're just like, oh, he's lying. So Lance is lying? Is he lying? Do you have proof? Okay. Scandal was the judge ruled the defense could not vet the alleged text messages. It's not a scandal at all. What are you talking about? They're on his phone. Discord messages are cross-examined Lance at this hearing. And we also got to see the dates on the phone. So what are you talking about? How did they hack? Did they hack the phone to get it to do that, Candace? Is that what you're saying? So what you are watching is a highly likely federal asset deliver an entirely unvetted narrative. So yeah, they're saying Lance Twiggs is a total, like, he's just a liar. He's just a complete and total liar. Let's see Tyler Robinson say that Lance Twiggs was lying. How about that? You know? Let's see. So they're saying, in my view, and in the view of most rational people who have been following, really, do you have any evidence of that? Any statistics, anything? Okay, you're just going to make that up. Is the FBI's co-conspirator who helped set Tyler Robinson up. Well, I'm sure Tyler Robinson will say that, right, Candace? Like, that is such cope. Pure cope. This is really bad. 30-6 could have done this. Do you even know Like, look at how this is bouncing around and stuff. We don't even know how the bullet would have looked. You said that it was fragmented. This didn't fragment. Look at how they're doing this. You said this was fragmented. You said that, Candace. You said that it fragmented, that it was a frangible round. Now you're ignoring that now. So here's this, here's the line. Here's 70 inches right here. That is 5'10". And then where do we see his head line up? Oh, where's the dot? Why isn't it up here? Here's the whole line. Here's that line right there, that crease. You notice how this dot doesn't have a line anywhere near it? This dot doesn't have a line anywhere under it? This dot doesn't have a line anywhere under it? And this dot, unless you're measuring this, then it does have a line underneath it, I guess, on the floor. But then you'd be measuring like, I don't know, like that far. So if I had to guess that this went all the way to 70 inches here, all the way to 70 inches, there would have to be at least above the only visible line we see. Are these the holes right here? If that's the case, they line right up with his head, don't they? And if that's the case with this dot right here, fascinating. It's almost like it lines up perfectly with his head at 70 inches. So I guess he really is 5'10", huh? And that just debunked everything. So everything that the court filing said, him being 5'10", they just ended up showing that it's 5'10". Isn't that wild? It's pretty crazy how that works. Pretty crazy. So, of course, I put this out there. 7 likes so far. Let me retweet this. I'm going to put it, like Seth Dillon and Paramount Tactical, Bronson, Jay Witt for sure. Just get this information to as many people to share it as possible. We're going to get James Lindsay. We'll get the quartering here. We're going to get Edie in here. We're going to get Lady Luck in here. I'm having to go off of everybody off the top of my head here. We'll get Cinema Shogun here. We'll get Milk Bar TV here. Is there anybody I'm missing, guys? Anybody I'm missing at all? Oh, I got a, let's see. B Barf the Bard. Heck yeah, $10. Thank you so much. Your channel is awesome. Thank you for working so hard and being sane. Candyland gives me anxiety. A strange folk. LOL, if you were our neighbor, we would watch y'all's kid for free if you need it. I appreciate that. That's very kind of you. Thank you so, so much. Thank you for that $10 too. Is there anybody else I'm missing here? I don't want to be rude. All right. Yep. Could realize that she did. So Candace Owens did confirm 1,000,000% that the guy in this is 5'10", which just happens to be Tyler Robinson's actual height. Isn't that crazy? Crazy how that works, isn't it? So, good job, Candace. Just completely and totally debunks herself. Makes herself out to be a moron. Good stuff. Let's see what we got here. Yep. Very, very, very silly stuff. I can hear my computer ramping up. Can't handle these tabs being open and the stream going, so it's going to crash the stream in a few. That's about on point. For some reason, it just starts doing that. Oh, there it did. It crashed. Yay. Now when I refresh it, it'll, for some reason, slow down. Yep, everything's good now. Now it's good and quiet. Wild how that works. Let's see. Tamara Neely and Josh Carr. What about them? Oh, duh. You want me to tag them too. Duh, I should have. I should have tagged them. What was I thinking? Sticking around, chilling at work. Heck yeah, thank you. Blinded by the Light. It's a good song. Kenneth Woody says, man, all the Goyim are taller than my Choctaw Jewish, eh? That's funny. Choctaw and Jewish. That's an interesting combination. It's like, so let me guess, you scalp people just enough to put like a little hat on them. Right? Just a light scalping. There we go. How's that? All right. Yep. Okay. Oh, Chicks on the Right. I should have tagged Chicks on the Right. Shoot. I forgot. It doesn't matter. She proved it wrong. She proved it. Candace Owens actually debunked herself and thought it was an own. Like, yeah, it's crazy. Absolutely crazy. It's hilarious. Let's see. Why is Imaru trending? Don't know with Imaru. You gonna react to your Queen Imaru's 48 minutes of lies? Oh, this is Mizkif. He's just an idiot. Let's see. Mizkif leaks Discord messages between Asmongold and Imaru when Asmongold used a variation of the N-word as his password at 33 years old. I don't care. Oh no. Wow. Such bad. No one cares about my N-word anymore. It's 2020. It's not 2020, yeah. It's 2020. Shoot, people didn't care in 2020. Who gives a crap now? They cared in 2016. They tried. Yeah, let's not Pro Clutch now. Yeah. Yeah, that's Mizkif right there. Yep. So dumb. Like, what are we doing? What are we doing? It's so crazy. It was me, Tyler Robinson. Yeah. What's that sound? Oh, we're outside now. All right, we're outside the courtroom. Wonder what we'll glean from this. Oh, they're getting interviewed. Some dude's interviewing. I don't know who's interviewing who, really. I don't know that guy, and I don't know this dude here. Oh, is that Brandon Tatum? Is this Brandon Tatum right here? Are we watching an exclusive interview from behind the Tatum? I think that may be Brandon Tatum.
Yeah, right?
Ah, man, every time he turns, it seems like it's him.
Also, like, you can't see obviously because it's black and white, but the way that the fight was set up was just like this, like dark piece of white on everything. So it's everything has like, it's just like this weird, and like made everything look like a little. Yeah, so.
Yeah, I think that's definitely Brandon Tatum.
It's like almost like to it. That's perfect.
All right. We got a little Tatum interview going on.
Yeah, it's crazy. They're all just sitting right behind it. So it's like, it was like.
Whew. I need to get me a snack because I think at around 4 o'clock, get some special food.
They wouldn't let us walk around.
Wonderful food that I will happily advertise on the channel. They are one of my favorites. See, you should know some Date Republicans videos. Those I seen the other day. Date Republican videos?
I can't not get a wide angle.
I didn't pay attention. That's the thing. When people send me videos, I actually do not pay attention to who I'm watching. I mainly just watch, unless I know who they are already, and then I'm like, oh yeah, I know that person.
One match I ever hit.
What did I do with that?
Yeah, it was pretty nuts, dude.
What was pretty nuts, dude?
So, yeah, I mean, there were some people.
Dude was looking at someone's pretty nuts, I guess. Weird. Never found nuts to be very pretty. Okay, now he's getting interviewed by them. Short statement, I guess. Oh, I caught him doing the shimmy. All right, there we go. Let's see. Oh, what did he say? See, your big problem is that the entire thing is not about you, Candace. It's about Charlie. It's about Erica. It's about his kids and his legacy. But time and time again, you've hijacked Charlie's story by smearing and slandering his wife, his organization, and his friends, and countless other people. Now you're even crashing out with the I'm not ending myself nonsense. It's not about you, Candace. And yes, I have questions. I've always had them. I've voiced them publicly before, but unlike you, I choose not to recklessly smear innocent people, organizations, companies, and entire countries without actual proof of wrongdoing. You, by contrast, target innocent people, ruin their lives for sport, inspire a wave of harassment and death threats against them. I think people are really starting to see through Candace Owens for the most part. Like, that's just such a great statement. Such a great statement, you know? Yeah. You've attempted to appropriate everyone else's grief and honest searching and replaced it with Egyptian planes and exploding mics. What an awful trade for the country and the world. For the country and the world. You're a record-breaking narcissist, Candace, but your credibility is also collapsing at record-breaking speed. Enjoy the crash out. Yeah, I agree. I absolutely agree. Do we get any, I'm hoping people see this video. Hoping people see this here. Yeah, she is nuts. Is this the one? Okay. No, that's that one. Debating on deleting that. Oh, wait, this. So, did I get the same ones? Yeah. Oh, that's not doing as well. Never mind. Debunked. Okay. The debunked one's doing really well. Lance Twigs. Yep. Good. I'm glad to see that. Glad to see that for sure. Let's see here. Oh. Right. I guess I don't need this anymore. Where is this? Oh, right here. Nice. We are seeing the courthouse in its natural habitat. But yeah, anyway. Oh, so what about those people? Was that a suggestion for me to? I see. Were you saying I should have tagged them? And show the top of Tyler's head. Because I think it was just zoomed out a bit. That's a good question too, I guess. In a sense, like, Candace does want it cropped up a bit. 1 second, guys. But yeah, guys, sorry about that. Anyway, yep. Was just getting a little bit of lunch planned, so I guess I could just chill in here. And I got a water some. I'm just gonna get. Oh. Let's see. Not a whole lot going on there. Just kind of keeping up with some of the stuff. We'll keep up with some more shenanigans from the candy crowd there. Let's see. Let's see what she's got to say. Let's see. This would be like me sitting down and testifying that Andrew Colvett told me he ended Charlie Kirk. No, it wouldn't. No, it wouldn't at all. You don't live with Andrew Colvett. He lived with Lance Twiggs. You see the big difference there, Candace? Like, that's crazy. That is crazy to say. Like, oh, well, that would be like me just saying that Andrew Colvett did it. No, it's not even close. They lived together. They have text messages showing. It's not like just sitting down and saying that. There are text messages. Like, there are text are bullets. There are lived together. They done. For speech. I don't know what just happened. Oh, it was my dude. This computer sucks so bad. I am very dissatisfied with this computer that I have. I'm not gonna lie. I am very dissatisfied with it. I have 3 times the memory in this computer that I do in my old one. I have a 5080. My old computer has a 1080. I've got the best AMD CPU in this computer. My old computer has a 7700K, which was one of the worst CPUs. In every way, shape, and form, except for gaming, in every other task, my old computer destroys this computer on speed. Destroys it. And I don't know if it's even the computer. It could be just Windows 11 from Windows 10 to Windows 11, and that's the problem. I actually have no idea. But I am really irritated with what is slowing down this computer in general. It's so frustrating. Hey, why is Patty Pimblett here? I haven't seen this guy in a long time. They believed in me from day one when I said I was going to do this, even though they didn't know what MMA was. Since day one, my dad has always... Oh, okay. Patty Pimblett is a very skilled fighter. And I have seen nothing about him for a long time. I wonder why that is. Let's see. Oh, and then he's, of course... we're just going to report this as spam. That's ridiculous. If I were to have done this, I would have gotten banned on X already. So I don't know why X is, like, not shutting this stuff down. Whoa, exclusive. Metropolitan Police is conducting a criminal investigation into at least $500 million, or $500,000, 500,000 pounds, in donations from George Cottle's mother to Reform UK. Wow, that's crazy. What does this have to do with it? Freaking spam. Like, dude, ridiculous. What are you doing, man? You have too many followers to be doing this. If it's like some 500 subscriber YouTuber, I get it. I totally get it. But you're not. You have like thousands of followers. That's ridiculous. Laura, I understand where you're coming from, but it's too early to be saying this. What if we end up finding out in court that there was an entire, like, underground trans, like, situation going on. You know what I mean? Like, I don't know. It would be crazy, right? Just saying. Windows 11 is bricked. Microsoft screwed things up so much. Yeah, they did. I very much loathe Windows 11. Windows 11 won't let me use some of my free plugins still. Still, they won't let me use my Klanghelm compressor, which I love, and can't use it. I can't figure out how to get it to work either. It's very irritating. Patty will be fighting Candace Owens. Oh, God. That's not a fight. That would be a death sentence. No, I would hope not to see that. That would be awful. That would just be brutal to watch, you know? KSL calm here. Fire your cameraman. I've never seen more gross incompetence from a court coverage camera in my life. Oh, yeah. We don't want to see the guy on the stand. We want to see the screen showing the messages. Yeah, that was dumb. That was dumb. For sure. Yeah, I agree. But it was KSL, so they're using the same camera guy as AP? Okay. I think Tyler Robinson, yeah. I think that's fair. This. All right. Like Phil Labonte. Even though, well, I guess I don't need to mention that. I think that drama was squashed. Yeah, no, Phil Labonte's cool. I'm learning one of his songs at the moment. I should practice that. That's what I should be practicing. I should practice This All That Remains solo. Though I will get to your guys' request. All right. You made a right-wing Pokemon themed Twitter in 2011 and got 600,000 followers in like 2 months. I had a panic attack crash out where I thought I wasn't the what? You weren't and you deleted it? That's crazy, though. That's actually really funny. You should bring it back. I don't think anybody else is doing a right-wing Pokemon theme. You probably get all those subscribers. Those people followed you for a reason. Hello, Bonk. What? In a question. Want from me? What? What? Ah! What? Let me put this down. So don't pass. What do you want? What? Explain yourself. No, not the keyboard. I have you a perch right here. You can put your paws on. Yes. Up. Right on the mouth, dude. Come on. What do you want? What? What is it? What do you want? Oh, here. Hey, what's wrong with it? What's going on? Confused. Oh. Got a whole pig ear. What's wrong with it? Don't like it? I have never, ever, ever seen him ever turn down a pig ear. Ever. What's wrong with I gotta go grab a bottle of water real quick, guys. And I guess I'm gonna grab him a different pig ear. For some reason, he does not like that pig ear. That's very strange. Buddy, I am back. Ooh, sorry about that. Oh, wow. 2 more subscribers, too. Thank you, guys. Alrighty. This is a wild, wild situation. Lots of notifications popping up, huh? What do we got? Improve it, I'll wait. I did. Timestamps no fake. Candace Owens' own words. I didn't make her do it. Okay. Yeah, I get the feeling, too. I get the feeling that Lance Twiggs is more involved, but don't have much evidence, unfortunately. Polyglot? What's a polyglot? What's a polyglot? Oh, okay. Interesting. So it's like a polymath, but for language. Okay. Received no classes on gender theory. Okay, yeah. Brazil is, yeah, of course, a very, very, very evil place, I think. Well, not an evil place. Brazil is the metal capital of the world, though. Pretty much. But yeah, that does suck. That's insane. But I mean, that's Brazil for you, right? All because they are neglectful on their education, even though they... Oh, deport Sneeko is trending? Yeah, this is just crazy stuff. Let's... The DNA evidence is fake. The physical evidence is fake. The video footage is fake. The Discord messages are fake. The gay boyfriend's testimony is fake. The family testimony is fake. Everything is fake. That is other than the speculations of a schizophrenic podcaster who have been making millions of dollars. Yeah. Yeah. Absolutely. Matt Morse here. Just fantastic evaluation here. Pretty simple. This dude looks a lot like a couple of the other people that I follow too. He looks an awful lot like what's his name? Oh, I just retweeted him. Follow him. Who is it? He looks a lot like this guy. Let's see. Is he? Where are you at? How many people have I retweeted? Don't pay attention. Go. There. All right, maybe I didn't just retweet him. Higby. Now we're into yesterday. Did I miss it? Yeah, I scrolled past him. I've retweeted him a couple times. I'm sure I'll find him, right? Graham Allen. Got him. Graham Allen. This is great. This dude's Graham Allen. See? Take a look. Oh, deport Sneeko. Right. Hold on. Deport Sneeko today? Heck yeah. People are texting me right now saying Nick Fuentes is on his show tonight begging me to get Sneeko deported. I warned Nick about Sneeko 3 years ago when he said he was friends with him and invited him to this conference. The Groypers are starting to regret their Chrislam LARP. Now they want a feisty Jewess to save them from the Muslims. And then she does it, though. Deport Sneeko, deport Hassan Piker, and deport Trita I don't know who Trita Parsi is. But Hassan and Sneeko, yeah, deport them 100%. Alex Jones is a national treasure.
I'm a Christian American nationalist, and white people are demonized by the left, by the Red Green Alliance, by Israel and everybody, and I'm sick of it. White people are 7% of the world population. Anglo-Saxons are like 2%.
There's no point in just preaching.
I am sick of being run over.
Okay.
And everybody that's declared war on us, I'm saying, okay, then.
You think I declared war on you?
And you want to declare
You think
war?
I declared
don't care
war?
if you're Israel. I don't care if you're a Muslim. I don't care if you're a Chi-Com. I don't care who you are.
Well,
you want to fight? You fucking got one.
Okay, so
The fucking games are over.
You want a war? You want a crusade? Now
don't worry. You're gonna get one, pal.
You're gonna okay. Then well done. You just played into the hands of the Jewish
That's right.
supremacists
No,
controlling
don't
our
worry.
country.
It ain't gonna
well
be.
done.
No.
That's what Elon Musk wants you to do.
It's gonna be
Alex.
cultural, so you can sit over there and fuck your daughters, and you
Good
can sit
God.
over there and
You're
marry
chipping out
fucking
now.
7-year-olds,
You're chipping out.
and you can sit over there and fuck little boys.
You're chipping out.
We want your shit out of here.
The predominant pedophile demographic in Europe, I told you, was white
bullshit.
guys. It's not.
This is 500,000 girls groomed by the Islamics.
250,000 was the estimated number. You just doubled it, and that's completely conflated.
It's 500,000 now. They had it in Parliament. And
Yeah.
here's the other thing.
500,000 estimated. You can look at the report.
We know Keir Starmer protected them. We know the British leadership are a bunch of pedophiles. I exposed that 30 years ago.
Yeah. Alex Jones, he's coming back. I think he's coming back around. He's coming back around. No, I think Alex Jones did it the regular way. He actually has access to a lot. Like, he used to be unbelievably fit. So Alex Jones is really, really, really knowledgeable on how to get fit and how to diet and stuff. I don't think he would have taken Ozempic. He's pretty good about that stuff. Just his history. I think Alex Jones is coming back. I've always given Alex Jones the benefit of the doubt for the most part. I mean, the thing about it is when people see Alex Jones crash out, he kind of earned it. He earned the ability to crash out. Like, look at what they did to him over the past 30 years. How crazy they treated Alex Jones, you know? Every now and then I expect a mental breakdown from Alex Jones. I'm like, all right, that's fair. Nobody has been made to look crazier. Nobody has been made to be dragged through the mud more than Alex Jones. He's been demonized and slandered and gone after way more than Rush Limbaugh ever had been. And Rush Limbaugh had quite the target on his back. You know what I mean? So I give him a pass. Every now and then, Alex Jones is going to say something idiotic. He's just going to. And, I mean, in all fairness, it wouldn't surprise me if the government and other people essentially made Alex Jones go full-fledged schizophrenic. I don't know that I would be able to handle the situation better than him. If I were slandered like that, if I were dragged through court, if I had constant threat of my life being destroyed every second of the day, if one of my reporters was executed, you know, I don't know that I wouldn't turn out to be as crazy as Alex Jones. It's like, it's sad to watch Alex Jones make dumb statements. It's sad to watch Alex Jones go crazy. But look at what was done to him. I haven't even seen Trump be hunted down and dragged through the mud nearly as bad as Alex Jones has been over the past, 20 years. 30 years, you know, and I'm surprised I'm surprised Donald Trump is not as crazy as Alex Jones. I don't know how Trump has held it together. He's made of different stuff, for sure. They don't build people like Trump like they used to, you know what I mean? Trump has got some thick skin. But then again, Trump is also, he's 81, right? Dang it, I accidentally... There we go. How old is Trump? Is he 79? He's 80. So he's 80 years old. He's an 80-year-old man, so he's kind of seen it all, you know? And, yeah. Well, I wouldn't say Alex is an idiot, because think about it. Alex Jones covered the Epstein stuff 15 years before any of it was ever public. If you look at a lot of the stuff Alex Jones has shown, he was talking about the atrazine in the water, making the frogs gay, all that stuff. 10 years later, he gets vindicated. Alex Jones is right way more often than he is wrong. But when he's wrong, he's wrong. And he doesn't really tend to walk things back often. You know what I mean? But it's not as common. He's pretty good, I think. And I just hope to see him come back to the same side of... I mean, he's not siding with Candace Owens. I think he's entertained it too much. But he's not straight up siding with her. Definitely have your radars out on Alex Jones, for sure. I wouldn't just... I'm not saying Alex Jones can't be threatened, can't be bought, or anything like that. But in general, yeah, I would, I don't know. I mean, always be suspicious of everyone, for sure. I don't think Alex Jones did it to himself. I really don't. I don't think Alex Jones did it to himself at all. The stuff that happened to him, no, he's not siding with Candace Owens 100%.
Our country is dominated by Jewish
Christian.
Like if you see,
I'm a Christian American nationalist.
You know what? I'll just pull up another window. I don't have to exit out of that. I still want to explore the Sneeko stuff. I'm not 100% sure why he's trending like that, but we'll find it. We'll get to the bottom of the Sneeko stuff. Sneeko's a fun little moron. He's an idiot. Now that's what stupidity looks like. Sneeko is the epitome of stupidity. Anyway, Sweet and Sassy joined as a troll. Thank you so much for joining. That's very nice of you. Let's see. Yeah, President Trump has been rung through the ringer for sure. I just don't know how Trump hasn't gone insane from it, to be honest. I really genuinely don't. Oh. Edie replied, heck yeah. Oh. It's hilarious. Let's see. Let's go to Alex Jones. Oh, crap. Because Alex Jones has definitely given Candace some lumps. Let's see what he said. Candace Owens, okay, so here's this. Candace Owens was ahead of the curve and I officially apologized to her. Oh, really? He apologized? Candace Owens plays a compilation of former Trump allies disavowing and criticizing. Oh, that's not on the Charlie Kirk stuff, though. That's over the Trump stuff. That's a different issue, which I disagree with Alex Jones on. I think he should not have apologized to Candace Owens at all, especially after what she did to Steven Crowder, but, you know, that's just dumb on Alex Jones' part. Like I said, Alex Jones is wrong every now and then. Hunter Biden caught lying again, though. Watch Biden's disgraced crackhead son tell Candace Owens that his father was not part of the Epstein class in the Sleepy Joe at sea. And that's what I'm talking about. He gives Candace Owens her lumps. He doesn't agree with everything on Candace Owens. Let's see. I want to see what he says about Candace Owens to Trump, Candace Owens to Elon. Where is the Charlie Kirk stuff? Has he said anything really about the Charlie Kirk stuff? There's this. December 23rd, 2025. After Candace Owens was caught red-handed, falsely claiming Congressman Mark Amodai was a part of the secret TPUSA meeting at Fort Huachuca, she is now attempting to flip the script by releasing a blurred document she claims proves her source was at the base September 9th. In the document, her star witness, now known as Mitch Snow, but listed as Michael Snow, claims he was detained on the base as a suspicious individual at the Southwest Border Mission Headquarters. Nice try, Candace. You and your witness have been reporting with no evidence that Erica Kirk, head of TPUSA, head of security, Brian Harpool, Cabot Phillips, and now Congressman Amodai were caught holding a secret meeting with Army officers. Now you want us to forget about that and focus on whether or not your source was on the base. You literally accused a sitting congressman of being part of a sinister plot and didn't bother to check and see if he was on the House floor live on C-SPAN that day. Thank you for your attention to this matter. You see what I'm saying? Like, don't completely be against Alex Jones. He isn't completely on Candace Owens' side, I promise. Now, is he being a little too friendly with Candace and agreeing with her on some parts that I disagree with? Of course. But that being said, Alex Jones is not... now, this is a bad community note. U.S. Representative Mark Amodai was not present. This needs to be... Oh, I did rate this as not helpful because, at the time, we did find out Mark Amodai was there. He was there the whole time. So, anyway, let's see. Exclusive, Mitch Snow claims he's the son of the Zodiac Killer. He used it. Yeah, I remember when Alex Jones covered that. It's hilarious. Let's go to latest, though. Let's end up going to very latest. Let's see. What is the latest thing he said about Candace Owens? Get ready, popular talk show host Jesse on Fire breaks latest on Charlie Kirk murder trial. What prosecutors are saying about Tyler Robinson, emerging evidence, Candace Owens, and so much more live. Okay. We'll check that out. Wait, actually, we can check it out. Let's see what he says about Candace Owens here.
The ground. Man, Charlie that day are giving hand signals. I mean, did you guys play Little League Baseball?
Is this John Cena? Jesse on Fire, is this John Cena? Is that what's happening?
Turned down 50 million.
Okay, let's see.
This guy and these Christians of America.
Just one clip for everyone to take a look at here before quick point Marie-based movement. Could have been out of shit.
Let's see what he says about this.
Just
wait, how did I get away
social
from
media because really overwhelming. Quick point, the footage that she's referencing. No audio on that? Oh, no audio on that. Okay, so then
I could hear the audio. You just
let me tell you what she said. So she says that while the family-only memorial was going on, supposedly.
Is this Jesse on Fire?
Supposedly there was a family-only memorial.
Is this dude pro-Candace or anti-Candace? I don't know Jesse on Fire.
This was before the memorial where they were videotaping things, and then the other one that was obviously done in a stadium. But she says that Andrew Coulter called her from the memorial, and they were obviously both very upset. She says, and she said that Andrews at the time said, "Candace, it was supposed to be you." And Sean Ryan stops her. And he said it was supposed to be you. The implication in the context of the interview being that Andrew was saying it was supposed to be you who got assassinated or murdered, of course. Right.
Yeah, it's all about Candace.
That's how Candace presented it. That's how Sean interpreted it. That's how I've seen everyone interpret it. And that started a series of, that and about 1,000 other things that came out of that interview. But that one specifically started a lot of conflict between the two of them. And I find that one notable because I'm pretty sure that I know what he was actually saying in the event that conversation is real. And I don't think it is in reference to Candace getting assassinated. I think that this has to do with what Candace had showed us in those previous text messages that he referenced in 2018, where Charlie and her were discussing her role in what Charlie saw for his future. He was apparently dreaming about the fact that he was going to die young, that he was never going to be able to see the mission through with TPUSA. And he said he can see it so clearly that she is going to be the exact wording is escaping me, but she's going to be the Iron Maiden that leads the charge and completes the revolution. So what I think he was talking about is I think he was saying it was supposed to be you that would lead TPUSA if Charlie was killed. I think because Candace said she didn't interpret it as him saying that it's supposed to be her to be assassinated at the time.
But if that's even true, how would Candace Owens have misunderstood that to think that she was supposed to be assassinated? Like, that would just prove that Candace Owens is lying.
And so that would stand to reason that as she, has built more and more and more and more and more suspicion on TPUSA, that she would think back on a thing like that and then reinterpret it through that lens. And I think it's much more likely that that's what he was referencing. But as a result of that and, many other things that she said, that started this off too. So we got other, other stuff to show. And actually, I'll finish showing you guys the other things that Candace said in this post because they responded to all of it. So she says, today is about emotion. You will hear Fed's narrative absent any ability for the defense to meaningfully been out of shape where female.
A dream to get married. 10 or 15 times. Literally, of just incredibly funny, incredibly smart people. Some are white, some are black, some are Hispanic, Asian, old, young, gay, straight, but who are just common sense and who just see the insanity of the.
Well, that sucks. So he doesn't give his opinion on this matter at all? Like, I wanted to see him react to Candace Owens to get his most. Okay, well, clearly that's not happening in this video. Did Candace Owens really say that it's good that Charlie Kirk passed away? Alex Jones cover. Okay. Video. Is Candace Owens claim that Benjamin Netanyahu true? Okay. Oh, thank you. Love you. Got me some mac and cheese. Heck yeah. Video claims that Candace Owens said it's a good thing that Charlie died goes viral, triggering. Okay. I want just something simple to see here. Must watch. Candace Owens confirms Alex Jones reporting from last year. FBI Director Kash Patel #1 job is to cover up conspiracies and stop real investigations. The Butler shooting, Charlie Kirk's assassination, and Epstein's co-conspirators. I don't know if that's true or not. For all I know, Kash is leftist in disguise. Or he's a Russian agent. You could tell by his complexion. That's such a stupid thing to even say. Candace Owens thinks Elon Musk is an alien. Well, that's one thing we might be able to agree on. Elon Musk very well could be an alien. Can't argue with that. Okay. He's at least a legal alien. So, I mean, there's that. Hunter Biden caught lying again. So, yeah, I mean, there are times and of course, he calls out Candace Owens' interview here. So, I don't know. Alex Jones is in and out. I'm just hoping that he comes back to the sane side. You know what I mean? That's all I do. I admire Alex Jones. One of the very first video that got me into politics is when I was working at Google. I was making all these rounds in the dark, pretty much, at this gigantic facility that had very little people in it. And the first video I ever heard pop up on my phone, and my phone could not even, turn off for a YouTube video or it would stop playing, so I had to have my screen brightness all the way down, set my phone down while I was walking around with my headphones and whatnot on. It was actually wired headphones. And, oh, hey, thank you, Argelia, for 30,000 subscribers. Thank you so much for that. So I had to have my phone brightness all the way down, and I was listening to the video of Alex Jones infiltrating the Bohemian Grove. That was one of the coolest, greatest videos, one of the most inspirational videos for this entire channel, to be honest. So I just don't want to give Alex Jones up. You know what I mean? I'm not ready for that yet. Not until I'm going to give Alex Jones a lot more leniency than I probably will most other creators. I'm not even going to lie. I'm going to be biased. That's just my bias showing. And, everybody's biased to some degree. That's my bias. I admire the guy a lot. I don't want to see him go downhill, And I hope he continues to call out Candace Owens and not side with her on silly things that can't be proven. You know what I mean? Which at least he has been doing. Even if it's not been on everything. So that's just kind of my whole thing. Let's see. Did we get any Candace Owens still lying to her cultists? Absolutely. Absolutely. Did I get that more shared out? Yes, she is insane. Yeah, exactly. She is insane. George is definitely in danger because Candace can't be doing well. That's funny. Yep. Oh, good. She hasn't blocked Edie yet, I guess. Heck yeah. Yeah. Let's go to this. See how it's doing. I'm just curious how this is doing. Yeah. This one's doing better. Let's see. The person she retweeted stated the picture was fake and he was trolling her. Oh, really? Wait, really? Oh, Midgray. I know Midgray. Oh my God. He just trolled Candace Owens so well. Wow. Why am I not following you? Also, I've interacted with Midgray so many times. That is amazing. Midgray, you are a legendary troll. You are a legendary troll. That is unbelievable. That is absolutely unbelievable. Not only did he get the exact measurement of this showing that he was 5'10", sent it to Candace. She freaks out and reposts it, not even paying attention to the measurement at all. And then he tells her it was fake. This is such next level trolling. This will definitely be the subject of the video for tomorrow or later on today. Wow. Where are we at on this hearing now? We should be almost here. Should be very, very, very close. Oh, I should turn the volume back on. Oh, is that 30 seconds behind? No, it says I'm caught up. What the heck? Should be about caught up. I guess I'm starting my lunch now, though. Some delicious mac and cheese. Yeah, we got like 2 minutes behind on this. But obviously it didn't matter at all. Not even a little bit. And I'm going to scarf this down. Then I'm going to learn some music. I feel like if Alex is sober, he can make quality content, but if he starts hitting the bottle, nah. I hope he's not hitting the bottle too hard. Oh, we're coming back. Yay. Here we are, guys. Perfect timing to check on that, huh? Well, in all fairness, so let me defend Alex Jones on the Sandy Hook stuff a little. Alex Jones never made the claim that these people were like, that it was an inside job. He interviewed 2 people who claimed it was an inside job. Alex Jones never sat down and actually formally said this Sandy Hook thing was fake. This came out all in court. And he never lost his court case based on that either. The reason why Alex Jones lost his court case was because the judge told Alex Jones, provide proof of how much money you made on the Sandy Hook hoax. And Alex Jones goes, I don't have any proof that I made money off of that like that. He goes, what I did make money off of was the entire segment of that day. Because, you know, Alex Jones does like an 8-hour straight like show. And he covers like 20 different things. He goes, I could tell you how much that show made, but I can't tell you specifically Sandy Hook. And the judge goes, well, because you can't tell me how much you made off Sandy Hook by itself, you're guilty. And you lose. Told him to bring forth a piece of paper that did not exist. Alex Jones then said, okay, well, I'm going to show proof. I'm going to file Chapter 11 or Chapter 9, whatever a business files bankruptcy under. And he says, I'll do that. And what that'll do is that will make all of my documents public. So that way, if I'm lying, somebody should be able to find my document and post it. He did that. The judge ignored him, still ruled that he lost. And that's it. That's how Alex Jones lost his case. Was over a piece of paper that didn't exist. So, yeah. It's crazy. It's completely crazy. So, there's that. But Alex Jones himself, unlike Candace Owens, you know what I mean? Never actually made the claim and said, this is what happened. Alex Jones just said, well, it's possible. Here are some people on it. I'm going to interview them. We'll see their take. They said that it was fake. They said this stuff. And Alex Jones said that's fascinating. And then he also brought on people who disagreed with that, which nobody ever brings up. So Alex Jones did both sides of coverage. Candace Owens? I have never seen her bring up any counter arguments. She never once. And, you know, I mean, that's typical Candace. She obviously does not want to bring on counter arguments. That would suck for her. So, you know, just is what it is. And Alex Jones definitely did a much, much more fair coverage on Sandy Hook than Candace Owens ever could have hoped to have done on Charlie Kirk. By far, you know. Why wasn't he able to prove the children were alive? Well, like I said, he didn't. I don't think that was the claim. Did those guys ever claim that the children were alive and that didn't really happen? I don't think that. I don't know. I'd have to go back and look at that. I don't know if that's what their claim was or not. It's been, how long has it been? 15 years since Sandy Hook? Was it 2012? That would be 14. So, let's see. 13 years ago, December 14th, 2012. Okay. So it'll be coming up on 14th this December, which is also interesting, right? Candace Owens' uncle, or was it her dad? Either Candace Owens' uncle or dad was the security guard for Sandy Hook at that point in time, right? Or was it Virginia Tech? I think it was Sandy Hook, right? Oh, if you want to join the Discord, you can also go into my description. That's a permanent link. So you can just click that and it'll always get you in every time. Let me get this. My keyboard charger. Keyboard is dying. Well, we should be. I thought we were going to be back like right now in the courtroom. Oh, we are back right now in the courtroom. Oh, nope. Where are we going? Where are you taking us, buddy? Put that camera down. Like all the kids were crisis actors too? I thought it was just the victims that were, like the ones that they interviewed were the crisis actors. I thought they meant that about the survivors. That it was the survivors that were the crisis actors. I watched her face, Blair White, on what's his name show? Oh, Dave Rubin's show? Yeah. Yeah. Or wait. Watch Candace Owens face Blair White, or was it someone else? Rubin. Oh, yeah, you're talking about Rubin. Okay, yeah. Yeah. Candace Owens versus Dave Rubin. Classic debate that just goes off the rails. One of the most hilarious things is just seeing Dave Rubin go, guys, as he's talking to a trans and a black woman. And the gay man is sitting there going, guys. It was the funniest thing ever.
Please be seated.
Hey, we're back. Here we go.
Court is back in session.
Hopefully the judge ain't angry no more.
All parties. We left off with Agent Davis being excused from the stand, no cross-examination, and turning to the state.
Wait. Has there been drama going down in my Discord that I didn't know about?
Sergeant, if you wouldn't mind coming forward and being brought into the courtroom.
How do I find band? That's crazy. Band. That's my personal thing. I don't want that. I want the...
Right, sir. Sergeant, if you'd like to come forward, you're still under oath from your previous testimony from the previous day. So if you'd just like to come up to the witness stand, be seated to your left. Behind the monitor should be a bottle of water. After you're situated, if you wouldn't mind just pulling that microphone toward you to ensure that the audio is picked up.
What's his name on here?
Mr. McBride.
There's only like...
Sergeant Falmuina, good afternoon.
Good afternoon.
11 people are banned. Why is Wendy Akupa banned?
Briefly covered some of your involvement in this case.
What happened with that?
The other day.
Why is she banned?
I want to return back to your initial assignment to this case. When were you first assigned to go to the campus of Utah Valley University?
On September 10th of 2025.
What time did you get that assignment?
I believe it was approximately 1:30 p.m.
And where were you?
Okay, hey, what is not index name on the Discord? Because there's not, like I said, there's a few people who are not, or there, it's not indexed, I guess you could say.
Where were you when you received that assignment?
I was at a headquarters office in Salt Lake.
And did you go directly down to the campus?
Yes, I did.
And will you describe what you're seeing as you arrived there?
Yes, when I arrived there, I actually arrived
that was a lie?
or near the south end
But I
of
didn't
campus,
cover
and that's where
I
I
never
saw
went down that rabbit
multiple
hole
police
in
cars,
Candace's
as
family.
well as multiple officers from various agencies. Then I was asked to respond to our command post, which was in the Fugel building there.
And the Fugel building, we've had some testimony about this, but is that just to the south of the courtyard?
Yes, that is.
And were you there while officers were securing campus?
Okay, good. Glad to hear that.
Yes, I was.
And do you know generally how that was done?
I don't know the specifics, but I do know that officers were canvassing the area, trying to look for a suspect, but also trying to see if anyone else was injured, and then making sure that the scene was secure and that no unauthorized people were allowed in.
And I think you testified earlier. What was your primary assignment?
My primary assignment at the campus, as well as throughout the case, was to oversee the crime scenes as well as the physical evidence.
Before you could do your work on the crime scenes, did the campus have to become secure?
Yes, it did.
And did that involve making sure there was no active shooter on campus?
Yes.
And did that involve officers searching buildings and clearing buildings throughout campus?
Yes.
Obviously. You would hope.
You mentioned that were there multiple areas that were processed by you and other crime scene analysts in this case?
Yes, there was. Would you like me to go over them?
Let me direct you to a few of them. Well, yes, please mention the scenes.
Yes, so one scene was a courtyard area, or I guess what we could also refer to as the amphitheater where the event took place. The other scene would have been the Fulton Library, where there were two bus stops. And then another would have been the wooded area. And then the last one would have been the Lolosi Center building, as well as the ground below.
He's unbanned.
All right, let's start with the rooftop. What was who was assigned to process the rooftop area?
The team that was assigned to process that was the Utah Bureau of Forensic Services, or also known as our state crime lab.
And generally, what does processing an area involve?
Processing includes documentation, sketching, as well as taking photographs, marking, as well as labeling evidence, and then determining how to package them properly, as well as also just trying to ID anything probative.
On the rooftop was evidence found?
Yes.
What types of evidence were found on the rooftop?
One item.
I don't know if he was band happy. We have 1, 4, 5. We only have 10 people banned. 11 with not indexed, but not indexed is not banned anymore. So, but some of these users I do remember needing to be banned, but I don't know why Wendy Okupa is banned at all. I just want to know if you guys know anything about that, because she was always a rock solid subscriber. So I'd like to definitely hear what's going on with that.
Of evidence that was found was a screwdriver. Another one would have been what we believe was the shooter's perch. That was determined that was easy to see at night. Using oblique lighting, we could see disturbances in the gravel on the rooftop. And then on the northeast edge, our team also found some swipes on the ledge of that rooftop that was also collected.
Swipes?
Okay. So northeast ledge. And
anybody want to fill me in what she means by swipes? I'm not sure what that means. Some swipes?
And is this the dropping off point?
Yes, it is.
Like,
you said swipes. What does that mean, swipes?
Swipes is, I would describe it as kind of hand marks or any type of marks that is left by something that causes some type of disturbance.
Okay.
And where on the ledge were those located?
Those were located right on the edge of that roof.
Right now?
Right on the edge of that rooftop.
We're at 99.
And then right below, we also had some other swipes as well as some other impressions. And then below that was a glass window where we also located some latent prints.
Okay. I want to return to the what you've referred to as the perch, the sniper position. Were measurements taken from that sniper
I bet
position
South Carolina
to
doesn't
the
want any,
tent where Charlie Kirk was seated?
Yes.
Do you know the distance?
Yeah, so the distance
one in more
from the
range.
perch area
Right.
directly to the tent where Mr. Kirk was sitting was approximately 415 feet. If you take into, and this, if you break it down, so from the perch to the tent, you're looking at it basically like this. And this is the perch and this is the tent.
And now
As
you're
opposed-
describing, I'm sorry, I have to make a record. You're describing an angle, a slope downward from the perch to the location of the tent. Is that
Yes,
accurate?
I am.
Okay,
Thank
go
you.
ahead.
Yeah, so the angle, so again, the distance, the perch to the tent was approximately 415 feet. If you think about it, or without taking into account the elevation drop, it was actually 410 feet, so just horizontal straight across. And then the elevation difference between that is approximately 68 feet.
Okay, 400 feet, 410 feet from the perch to the tent with a 68-foot vertical drop. Is
Yes.
that right? Yep. On the
As we know, 300
rooftop,
feet
were
is
shoe
100
impressions
yards.
found on the
So-
rooftop?
Yes, there was.
Did those who
So you're telling me
processed
he
that
made more
area
like a
of the crime
125-yard
scene
shot?
collect the latent prints and the shoe impressions that you've talked about?
Yes, they did.
And this is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low-C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that the area in the glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low-C Center?
Yes.
And that's the area where we see in a video an individual drop from the roof?
Yes.
I want to move on to another area, the courtyard. First, will you describe what that area of the crime scene looked like?
Yeah, so when I arrived on scene, you have different steps. I believe there were maybe like five or 6 covered in grass. When I was there, there were personal belongings spread throughout. There was a tent towards the west end of that courtyard area, as well as some banners and some barriers as well.
Was that area processed for evidence as well?
Yes, it was.
What was done to process that area?
Photography, as well as just examining the tent area to see if there's anything there.
And who is assigned to process the courtyard area?
The FBI.
I want to take you to another area, a wooded area. Was there a wooded area that was processed as well?
Yes, there was.
Will you describe, first off, where that area is?
Yes, so this area is located northeast of the Low-C Center building, and it is across from Campus Drive.
Your Honor, could we publish Exhibit 35, please?
Yes.
And if I may approach the witness, I'll put up the hard copy of this exhibit as well.
All right.
Thank you, Angel May. And thank you, Kenneth Woody. I appreciate it. Woo, I didn't expect, I figured everything would just be on the TV. They got the full printout going.
Can we publish the oh, thank you. All right, on the screen in front of you, will you take a look at Exhibit 35?
Yes.
Do you recognize that?
Yes, I do.
Will you take a moment to orient yourself on that map and tell me when you've found the relevant points that help you understand what this map is of?
All right, so if that's the case, what's the point of all
Do you
this
see
here?
the courtyard on that map?
Yes, I do.
Could have just had it on the TV.
Kimberly, can you zoom in to the courtyard area, kind of the center of the... There's a pointer on the screen. Is that the courtyard?
Yes, that is.
Super duper pooper scooper El Nino.
All right, now,
That's for
the
sure.
Low C Center, will you
nuts.
describe, well, let's jump to the wooded area. Where is the wooded area that you're talking about, seeing that was processed?
Yep, the wooded area, if you go from the courtyard and you go northeast, you're going to come across this big parking lot. And then if you just go directly north
We're
to
doing this
that.
anyway, okay.
Okay, this is, at this point, it might be easiest for you to actually indicate on the physical map. If you don't mind just standing up,
Do we not have like a stylus we can give her or something for the screen? Like, for real? Why are we overcomplicating this?
Yes, so the wooded area is approximately right here in this area.
Okay, so just to make a record of the area, on the northern, I guess I'll say, and north is up on this map, is that right?
Yes.
Do you know where Campus Drive is?
Yes, Campus Drive is this road that winds right along here.
Okay, and so that's kind of the windy road that begins in the upper left-hand corner of the exhibit and winds down through the center of the map and kind of exits to the middle right side of the map, is that right?
Yes.
And the wooded area, where is it in relation to the Campus Drive?
It is north of Campus Drive.
Okay, kind of in that, probably the center right of the map, is that right?
Yes, that's correct.
Will you describe, first off, what is on the south side across the street from the wooded area?
Yeah, so on the south side of the south side of the wooded area, we have the computer science building, which is to, I guess, east. And then we have a parking structure, and we have a walkway along here in between that connects the computer science building and the Losi Center building. And then right onto the southwest of the parking lot area is going to be the Losi Center building.
Okay. Now, you referred to the area across the street from the wooded area as a parking structure. That's a parking lot, right?
I'm sorry.
And there is a parking structure on campus, correct?
Yes, there is.
But that's different than the parking lot you just mentioned.
Yes.
Okay.
I mean, I could understand why she would think that. She
back
doesn't know
to
if
the
there's a
wooded
level
area.
below this.
What was found?
That's
was
fine.
anything found in the wooded area of evidentiary value? You can sit down. Thank you.
Mistakes like that happen.
You can take that.
May you repeat your question?
Was anything of evidentiary value found in the wooded area?
Yes, in the wooded area, a rifle that was wrapped in a dark colored towel was found there.
And how did you learn about that?
I found that out because just a little bit before 6 p.m. That day, I received a call from Utah County Sheriff's Office, who was tasked with searching that area.
Do you know why they searched that area in the first place?
Yeah, so they searched that area because I received a video that was from the UVU security footage. This was received by our command post on scene, and it showed who we believe was the shooter on the rooftop run from the southwest corner all the way to the northeast corner, jump down, and then continue to the northeast side of that campus, and then cross the street to Campus Drive, and then the suspect was out of camera's view after that.
Okay, so he ran basically toward and into that wooded area.
Yes.
All right. What were you told from the sheriff's office?
I was told that they found a gun, and from there I asked them to hold the scene, and that myself and FBI ERT team, the lead, Special Agent Kamak, would be en route.
Okay. FBI ERT, FBI Evidence Response Team, right?
Yes.
All right. Did you go to that area?
Yes, I did.
Did you observe the weapon?
Yes.
Will you describe what you saw?
Yep. What I saw was a rifle that was, or at the time before even having removed it, we found, or in the bushes, we found all you could really see was just a dark towel there. So pictures were taken of that, and then eventually the gun or the towel was removed, and then once we removed the towel from the bushes is when we uncovered that the towel was actually used to wrap the gun in.
Have you reviewed State's Exhibits 10, 10.1, 10.2, and 10.3? Do you remember reviewing these?
Yes.
And are they accurate photographs of the weapon when it was recovered and shortly thereafter?
Yes.
I move the admission of State's Exhibits 10,
Yes, this is the
10.1,
prosecutor.
10.2, and 10.3.
Defense?
No additional. Or the prosecution team, I should say.
All right, and as it relates to publication, if any?
Yes, I would ask that these be published at all 3 levels.
All right, any input, Mr. Burt? Same objections. All right, I'll note the standing objections from defense. Those are overruled. And 10.1, 10.2, 10.3 are admitted into evidence and may be published both in the courtroom and through the use of the camera.
If we can please publish number 10, thank you. You have in front of you on the screen Plaintiff's Exhibit 10. Will you describe what we're looking at here?
Yes, what we are looking at here is actually the bushes where the dark colored towel and the gun were found. You can kind of see the dark colored towel towards the right-hand side of the screen in the middle, right middle.
Kimberly, can you zoom into that area, please? All right, is this a better view of the towel?
Yes, it is.
If we can go to Exhibit 10.1.
A little hard to see it there, but yeah. Oh, I'm sure we'll find.
Will you
the piece
describe
of
what
this
we're looking
thing
at in
here.
Exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel
I
that
see it
was
there.
used, or of the towel and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak moved it from the bushes. We then placed it on
Oh, yeah, I
a
forget this
cardboard
lady has a
box,
stutter.
took pictures of it,
So, like,
and then we removed the towel,
light.
packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is the dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
You described making the rifle safe. Will you describe what that is?
Yep. And forward to whether it be to load it, lock it, as well as extract anything that's in it. Unlike a semi-auto gun, that is one every single time you pull the trigger, a bullet will be fired, and then from there, a casing will be extracted out, as well as a new cartridge will then be automatically fed into the chamber.
So if you shoot a bolt action rifle, does that spent shell casing automatically exit the gun?
No, it does not. It will stay in there until the person that is handling the gun actually removes the bolt, or actually pulls the bolt back, and then the casing will be extracted out.
Were you present when this weapon was made safe?
Yes, I was.
Will you describe what was found when that happened?
Yeah, so when we rendered the gun safe, we found in it, when we removed the bolt back, we found one 30-06 cartridge case, or say a fired cartridge case, and we also found 3 unfired cartridges, all with engravings on them.
Okay. I want to make sure we understand the language you're using. When you say cartridge case and you say cartridge, what do you mean?
Yeah. So a cartridge is basically the round itself, right? The whole round. And the round consists of the cartridge case, and then the powder, and then the bullet on top. So the cartridge case, the term is used for something that has been fired already. A cartridge is an unfired round.
Okay. Cartridge is the unfired round that still has the bullet, the powder, and all that.
Yes.
cartridge case is the fired, is a round that has been fired and it's just the empty brass casing, is that right?
Yes.
Okay. Was there any, so there was, I just want to make sure I understand, a fired cartridge case and 3 unfired cartridges?
Yes.
Was there anything distinctive about these items?
All 4 of them had engravings on them.
So we got the clear image of the rifle. She's talking about the rounds with the engravings. I don't want to interrupt her too much here, simply because this is the stuff that I've been looking for. This is exactly what I've been wanting to talk about, for sure. I'm hoping that Candace Owens really is paying attention very closely here, guys. Let's get back to the. Wait, you still have no sound? Do y'all not hear anything? D Hampton? Wait, YouTube just YouTube shutting chat down. Did they do that? Oh, I see. I'm getting poor reception right now for some reason. Why? Strange. Huh. I guess it glitched out or something. Have sound. Sound was cutting out by exiting, re-exiting, stream fixed. Okay. Sounds like, yeah, YouTube's having a little bit of issues today, guys. YouTube's having just a little bit of issues. Don't know why. Really not sure why. But, yeah, they're very strange. It's very strange. All right, let's get to this. Let's hope we see images of the rounds.
Did you observe those engravings?
Yes, I did.
Did you observe them right there on scene?
Yes, I did.
And what was done with, let's talk about each of those things. First, the towel. What was done with the towel?
The towel was packaged and then it was eventually provided to the FBI.
What was done with the firearm?
The firearm was also packaged and then provided to the FBI as well.
Did the firearm go to the FBI or the ATF?
Oh, sorry, correction. First it went to the FBI and then to be in their custody, and then it was then sent to the ATF lab.
Okay. And the rounds, the cartridge and cartridge cases,
Yep.
cartridges and cartridge case.
Yes. All those were packaged, originally provided to the FBI, then was sent to the ATF lab.
Right. And were each of those items tested?
Yes, they were.
And in the testing, were they photographed?
Yes.
Have you reviewed the photo, and were they photographed by the ATF when they were tested?
Yes, they were.
Have you reviewed their photographs?
Yes.
And were you previously shown States Exhibits 19, 20, 21, and 22?
Yes.
And are those photographs that the ATF, or that you received back from the ATF, of those cartridges and the cartridge case?
Yes.
Did they have the same appearance and etchings that you saw when you observed them removed from the gun?
Yes.
And did those photographs accurately capture those etchings?
Yes.
I move to admit States Exhibits 19 through 22.
Mr. Burt. All right, I'll note the standing objections. Those objections overruled, and 19, 20, 21, and 22 are admitted. And as to publication, Mr. McBride.
I would move to publish these exhibits at all 3 levels.
All right, any further objection from?
No further objections.
Thank you. Again, I note the standing objections as are overruled. They may be published both in the courtroom and captured by the media camera.
Let us start with Exhibit 19, please. What are we looking at here in Exhibit 19?
This is the cartridge case that was recovered from the gun.
Here we go.
And what position was this in the gun?
This was this is what was in the chamber.
Okay. And the chamber meaning that's where a cartridge is before or when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notice this bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's?
And to page 3.
This.
And question mark, correct?
Yes, question mark.
All right, if we go to State's Exhibit 20.
Why were they all fired, though? Yes, yes! SPRG.
Is this
Springfield R&P.
a photograph of one of the cartridges that was found in the gun?
Okay,
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit
Let's see
20?
if we get
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber than a .223 round?
Yes, it is.
It's an accelerator
Will you
round.
look at page 2 of
I'm pretty sure.
Exhibit 20? Will you read the
Boom!
markings here?
This is it. Right here. The accelerators were intended to allow the hunter to use their deer rifle to shoot varmints or smaller game, but were not accurate enough. This is it. 30-06 R&P Springfield. That is crazy. There we go. Are all R&P rounds accelerators? I don't know if they're accelerators or not. Let's do a little bit of a deeper dig here. That's kind of crazy. If we found out that this was a varmint round, then it just debunked everything Candace Owens could have possibly accused, like, any of these people, not just Candace Owens, anybody who has said that 30-06 should have went right through him. No. So here we go. Let's take a look. Design. R&P stands for Remington Peters. Okay, maybe not then. Signifying the case was manufactured by Remington. The Springfield. Okay, so maybe not. RP 30-06 for accelerator. Okay. Maybe we need more info. We're going to find out. But it very well may be. I mean, this looks... I'm not able to tell from this if this was what kind of round this is at all. But that is very, very interesting to have exactly that. But it might not show anything. The bottoms don't always show exactly what kind of round it is either. But if that's the case, we'll see. We'll definitely see. I'm going to do some more research on this.
Here.
Hey, fascist.
And page 3.
Oops. Let me get my page back.
Catch.
And page 4.
Up arrow, right arrow, down arrow, down arrow, down arrow.
All right, let's go to Exhibit 21.
Is that a cheat code thing in a game like Grand Theft Auto? Is that like infinite ammo glitch? The up, right, down, down, down?
And was this another round that was found in the gun?
Yes.
Will you read the inscription here?
Oh, Bella Chow.
Page 2.
Chow, chow.
All right, let's go to Exhibit 22. Another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read.
Page 2.
This, comma, your, or correction, this, comma, you are.
Page 3.
Gay.
And page 4.
LMAO.
Okay.
All right, after processing the scenes there at Utah Valley University in Orem, did you go to St. George?
Yes, I did.
And what was your role in St. George?
My role was overseeing the execution of the search warrants at both Mr. Robinson's residence as well as his parents' residence.
And we've had testimony that Mr. Robinson was arrested there. Was he fingerprinted and his DNA taken?
They were actually taken at at the Utah County Sheriff's Office jail.
After he was transported to Utah
Yes.
County. Okay, you said that there was, were items of evidence collected from him after he was arrested?
Stamp.
Yes, there was.
From his person. What were those things?
They were his clothing that he was wearing at the time of his arrest, to include shirts, pants, underwear, as well as shoes and anything that were in his pockets.
Do you remember what tops he had on?
I believe it was a maroon top.
And
it could be
was
anywhere
there
from
any other,
125
top
grain
layer
to
that
220
was collected
still,
that you
so.
recall?
I don't recall.
Okay.
Don't know.
Let's go to, you said there were a couple of homes that were searched there, is that right?
Yes.
Whose homes was that?
One of them was where Mr. Robinson and Mr. Twiggs resided, and the other was Robinson's parents' residence.
I want to ask you about the defendant's home. What items were, will you describe some of the items that were collected from that home?
Yep. Some items collected in that home were a Dremel tool and its bits container, as well as two Remington boxes of 30-06 ammunition, as well as some 30-06 cartridge cases, and
gonna show
a
it? It's the
handful
box?
of long guns or rifles, a revolver, as well as a burned paper.
All right, I want to ask you about clothing as well. Was any clothing collected from the townhome?
Yes, there was.
How about shoes?
Yes.
What kind of shoes?
Converse.
2 shoes were collected from the home. One was a Converse shoes, gray in color with white laces, I believe a size 10.5. And then another Converse shoes that were also gray, but had gray laces instead, but were of a different size that I can't remember.
I think you said that you collected boxes of ammunition. Do you remember what caliber that ammunition was?
Yes, there are a handful, but the one that I recall was 30-06.
Okay. What kind, though?
And you also said you found some cartridge cases. Do you remember what caliber those cartridge cases were?
Yes, those were also 30-06.
If we can display just to the witness Exhibit 23. Do you recognize State's Exhibit,
She does
Plaintiff's
look like
Exhibit 23?
Siva kind of, right?
Yes, I do.
CSI. Or is that
And,
CSI? I can't.
is that an accurate photograph of
NCIS, never mind.
the cartridge casings and some of the bullets that you found?
Yes.
I would move the admission of Plaintiff's Exhibit 23.
Mr. Burt?
No further objections, Your Honor.
All right, I'll note the standing objections by defense. Overrule those objections and admit into evidence State's Exhibit 23 as to publication, Mr. McBride.
I would move to publish at all 3 levels.
All right, it is published to the courtroom as well as maybe broadcast via the camera.
As that's coming up,
Please tell me they're going to show us that evidence.
where did you find these?
I found these in what we would consider the spare bedroom, right next to Tyler's bedroom, on top of a safe.
How do you know which bedroom was Tyler's bedroom?
We determined that based off of some documents we found in what we believe was Tyler's bedroom, such as mail that was addressed to him, as well as some school documents as well.
And again, in relation to, will you describe the layout of the house in that area?
Yep, so this was on the second floor. As you're coming up the stairs, if you turn the left up the stairs, you're going to run into 2 bedrooms, and that is on the south end of that residence. The southeast bedroom would be Tyler's, and then the southwest would be the spare bedroom. Again, if you go back to the stairs and you make a right-hand turn, that is where you're now on the north end of that residence, and that is now Twig's bedroom.
And where were these items here in 23 found?
These were found on the southwest, or in the southwest bedroom, the one right next to Tyler's bedroom.
And you said on top of a safe?
Yes.
Okay. All right. Will you describe what we're looking at in Exhibit 23?
Exhibit 23 are the 5 cartridge casings we found on top of the safe. All were 30-06 Springfield caliber, and one of them had an engraving that said "test shot" on it.
You've talked about Springfield, Remington. Are these 30-06s? Are they the same type of round as was found in the gun?
Yes.
All right, did you find any .30-06 weapons in that house?
No, we did not.
All right. Did you search the closet on the first floor?
Yes, I did.
What did you find in the closet?
In the closet, we found on the ground some shooting targets with perforations in it, as well as on the shelf, we found a Dremel tool with bits container.
All right, a Dremel tool with bits. What is a Dremel tool?
It's basically like a handheld device where you can make etchings or engravings on things.
What are bits?
Bits would be I guess like a sharp edge or something that would actually cause the etchings that you would put into the tool.
Is this kind of like a drill bit?
Yes.
Okay. And what did you do with the Dremel and the bits?
We photographed them in place, took additional pictures, packaged them, then sent them for testing to the ATF.
All right, you also mentioned targets. Were those targets photographed?
Yes, they were.
I want to show you on your, and have you reviewed Plaintiff's Exhibit 25 before?
Yes.
And is that an accurate photograph of those targets that you found?
Yes.
I move the admission of State's Exhibit 25.
Mr. Burt?
No further objections?
All right, I note the standing objection, and those objections are overruled. Stacey?
Excuse me, sorry.
Oh, well, did you want to, in regards to publication?
Yes, I'm so used to admission before publishing. I would move to publish those at all three levels.
Any further comment, Mr. Burt?
No further objections.
Again, all right, noting the standing objections, those are overruled. State's Exhibit 25 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Will you describe what we're looking at here?
Yeah, so these were shooting targets we found in the closet, and each of them have have perforations in them.
When you say perforations, what do you mean?
Holes in them.
Those holes consistent with?
Objection. Foundation on this opinion.
Mr. McBride, do you want to weigh in upon that objection?
No, I'll submit it. I'll lay foundation if the objection is sustained.
I'll sustain the objection.
All right. Why? Holes. Have you ever shot a gun before?
Yes, I have.
When you hit a target, what happens to the target when it's hit with a bullet?
Hit with a bullet, there's holes in there, what we call perforations, because there's an entrance as well as an exit.
Looking at State's Exhibit 25, I'm going to ask the question that was objected to. You said there's perforations in those. Are those consistent with bullet holes?
Yes.
And I would ask you to describe where those perforations are there's three targets here, right?
Yes.
Let's look at the far right target first. Where are the perforations in relation to the bullseye?
They're all probably within the 7, 6, and 8 ring.
Is there a perforation up at the upper left-hand corner of that rightmost target?
Yes, there is.
Ooh, what is the funniest nickname I've heard for Candace Owens? Let me think on that one. There's a lot of them.
Do any of those hit the bullseye?
No.
Candy with
the
the
center,
DEI at the end of it's
target.
pretty funny.
Will you describe where the perforations are in relation to the bullseye there?
It is closer, but still not it. Most of them are to the left of the bullseye and rings, let's say 9 and 8.
All right, and then the leftmost target, will you describe where the perforations are there?
Yeah. The perforations are actually closer to the bullseye as well, actually one being in it.
Okay.
All right, you described also collecting a burnt note. We can take down 25. Thank you. Will you describe where that note was found and what it looked like to you?
Yeah. The burnt note was found in the trash
Well, I guess
can
it depends on how far away
located
it
in the
was.
kitchen.
If
The
you
way
did
it
that at, like,
looked like to
400
me,
yards,
it looked like, say, you
probably
had
not
like
bad
a
for his
campfire and someone burns paper.
experience, you know what I mean? But he could have been
What
citing
was
in
done with
that scope too.
That was also collected and that was sent to the FBI for analysis.
Was it photographed?
Yes, it was.
And have you reviewed State's Exhibit 24?
Yes.
Is that a photograph of the note?
Yes.
I move the admission of Plaintiff's Exhibit 24.
Mr. Burt?
No further objections.
All right, and to publication?
I move to publish at all 3 levels.
Yeah, the
All right,
grouping was good.
I'm going to
That's
note
for
the
sure.
standing objection by defense, overrule those objections. And State's Exhibit 24 is admitted into evidence and may be published in the courtroom and may be captured by the media camera.
Do you see here on the screen Plaintiff's Exhibit 24?
Yes, I do.
It looks like as to the evidence tag, it's actually upside down. Is that right?
Yes.
Is there any, does it look like there's any writings on that note, on that burnt paper?
Yes.
Will you point that out for the judge where the writing is?
Yep.
And describe what you're pointing at, kind of the general location on the image?
Yeah. So the part that I'm pointing out is the paper that you can you can still see the lines in them, and as well as some handwriting as well to the edge, the left edge of that piece of paper.
All right.
Right here. And probably right here.
Have you also observed the image of a note that was recovered from Lance Twiggs' phone?
Yes.
And I'd like to show you side by side Exhibit 24. And there on the left, you see Exhibit, well, that's good. There on the left, we see Exhibit 24. Do you see that?
Yes, I do.
On the right,
Little
you
Yeasty, I
see-
think is my
excuse me,
favorite
on the
nickname.
right is 24, on the left it's 16.
Let me stop you, Mr. McBride. I'm not sure, is this being broadcast?
Let's take that down.
What is it?
All right.
Exhibit 24. Thank
Is it
you,
just
Your
the
Honor.
letter that we just saw?
Excuse me, Exhibit 16.3.
Lord of East Winds, though, that's a pretty good one.
I would move to publish Exhibit 16.3 and 24 side by side. I think they're currently on the council monitors.
The Yeasty Boys is pretty.
So
Little Yeasty,
16.3
Little Yeasty
has
is my
already been
favorite. It's so-
admitted.
And I don't remember the court's order if this was to be captured by electronic media or not.
No, it was not.
Okay.
Is that does that comport with defense's memory as well?
It does.
All right, so 16.3 was published to the courtroom, but not to be captured by the media. So
Very well.
as it's, and what is your request?
To comply with the court's order.
All right, so 16.3 and Exhibit 24 may be published side by side only to the courtroom itself and not on to be captured by the camera.
Huh. Why are you looking at me like that? Stop that. Thank you. God. Oh, this is just going to be off the record for a bit, I guess. Oh, you're not that far behind. Dang it, what's the letter? It's all burnt up. It's all good. You'll catch up. Eyes of a Strange. That's the guy. Did he just comment? Where is he at? Where's that boy at? Oh, is he not in chat?
Also acknowledging that the
There we
magistrate
go.
can weigh the evidence.
Now we're
and
back.
is not weighing in on this evidence, solely admitting it. Well, it's already been admitted, but as it relates to the testimony, the court is going to overrule the objection and allow the testimony to be given. Again, whether the court accepts or doesn't accept that will be a determination made when determining probable cause.
Oh, in Discord? Oh, okay. Yep,
Thank you.
that's him.
Do you see
That's
any
the guy, boy.
consistencies that you're able to look at?
That's Okai. Also known as Kentucky. Now they muted it again. Boy. Sometimes you just got to let the muscle memory kind of just take its toll. You know, just let it do its work. You memorize it, then you get the... You can kind of get it going. Kind of wondering, how should I go down on my index? Should I stick with the middle?
Did you also collect
Oh, we're back.
the defendant's car?
Yes,
Where did you collect that from?
that was collected at the Robinsons'
Ooh, they're
parents'
getting
home.
loud. Come
And
on.
will you describe that vehicle?
Yep, that vehicle is a,
that's
say, a
better.
gray-colored Dodge Challenger.
Oh, I thought it was black. Guess it's like a charcoal.
All right. You've mentioned that you sent several items to the ATF and the FBI for testing. And did you receive reports back from both of those entities with results of their testing?
Yes, I did.
I'd like to show you on the witnesses screen only right now, or counsel screens, Exhibit 30.
All right, while you're doing that, Mr. McBride, and also, could we go ahead and take down State's Exhibit 35? I know it's just in the background, but just to
Get it out of my court.
be consistent on displaying of exhibits.
Get it out of here.
All right, thank you.
Is
You
this
may
a different
proceed.
guitar from yesterday? I got just my 4 over here. That's the Majesty.
Plaintiff's Exhibit 30. Do you know what this is?
Yes, this is the ATF report that I received regarding the DNA testing on the gun and cartridge casings. Or sorry, correction, cartridge case and cartridges.
Thank you. And is this in the same condition as it was when you received it?
Yes.
Your Honor, I'd move the admission of Exhibit 30.
Mr.
No further objections, Your Honor.
All right, I note the standing objections, and as to publication, Mr. McBride.
Yes, Your Honor. This exhibit deals with DNA testing on the rifle and the cartridges. We would move to have it published at all 3 levels.
All right, so noting the standing objection by defense, I'm going to overrule that objection pursuant to Utah Rule of Evidence 1102. State's exhibits, and this is 30?
30.
State's Exhibit 30 is admitted into evidence and may be published on screen in the courtroom and for the media camera.
I want to ask you a little bit about the format because it may be helpful to understand here. But On page 1, under the exhibits, we have here a list
was
of
really hoping
items
we'd
that
see
were
the
sent
box
in
of
for
ammo.
testing and comparison. Is that right?
Yes.
And throughout the report refers to the items compared by the lab number. Is that right?
Yes.
So if we can scroll down just to the bottom of this first page, and here in the DNA analysis section, again, we see that the report or the author refers to the items by their exhibits numbers, right?
A rifle with possible ridge, detail, and/or smudging, and 3.1 is swabs of one
What just
30-06 cartridge
And that 30-06 cartridge came from where?
from the firearm.
That was a weird
Can you
cut.
read paragraph D?
This is all
The
live,
DNA
so I didn't do
profiles
that.
are at least 1 trillion times more likely if they originated from Tyler Robinson as a contributor to the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
Okay, statistical analysis calculation number 6, exhibit 1.9, where is that from?
1.9 is the swabs of possible ridge, detail, and/or smudging on the optical accessory of the rifle.
Is that a scope?
Yes.
Okay. Will you read paragraph D?
The DNA profile is 6.28 billion times more likely if it originated from Tyler Robinson as a contributor to the major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
Okay. On number 7, I'm not going to read that. I think we've gone through this enough. That's the last one in this report. Is that correct?
Yes.
All right. We can go to exhibit 32. 31 was previously received. And just display this on the screen of the witness, please.
Everyone in the courtroom right now? Just
I think it might display on the gallery.
Hey, we'll see you later there, Brusha. Thank you for being here.
All right, thank you.
Yeah, I mean,
Can you
it's
see
obvious
exhibit
Tyler Robinson
32
did all this
on
stuff
your
here.
screen, Agent Feldman?
Yes.
DNA,
What is this?
everything
This
else,
is an
you know.
ATF report that I received in relation to the gun as well as cartridge case and cartridges.
And is this report in the same condition as it was when you received it?
Yes.
I move the admission of State's Exhibit 32.
So question for you, was this the report that was previously disclosed in one of the early motions?
Yes.
All right. All right. To Mr. Burtz.
No further objections, Your Honor.
All right. And for publication level?
All 3 levels.
All right. As it relates to State's Exhibit 32, is accepted into evidence, may be published in the gallery as well as electronic. The media camera can capture it. And I note that this has been previously disclosed publicly from an earlier filing, I believe from either late last year or early this year. So for those reasons, it's accepted into evidence and may be published at all levels.
Your Honor, it's 2:30. I probably have 10 more minutes. Would you like to take a recess now or after I finish?
Let's just do the 10 minutes.
Okay.
Are we
All right,
recessing again?
Exhibit 32 is in front of you.
Okay. I'd say too soon.
And what was being analyzed in this test?
What was being analyzed would have been the cartridge case as well as the bullet fragment and the lead fragments that were recovered from Mr. Kirk at autopsy.
Right. Same question on structure of the exhibit. The lab numbers and agency numbers are listed here on the first page, right?
Yes.
And if you want to know what the report is talking about, you have to refer back to there, right?
Yes.
All right. I want to have you read, if you can scroll down to the bottom of page 1. Thank you. I would ask you to read the second line under results of examination.
Yes. The Exhibit 1 rifle was test fired and found to be in operable condition. The test fires were designated as Exhibit 1.11.
And again, Exhibit 1 rifle is what?
Is the one that we found on campus.
Okay.
I just started showing my
Exhibit
kids the
2,
show Recess,
if
by
you'll
the
look
way.
at the next, skip the next line and then go to the Exhibit 2 cartridge case, will you read that sentence?
Yes. The Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle.
Okay, now I want to jump back up to the top where it lists the exhibits. 2 through 5, will you explain what those are and where they came from?
Yes.
Thank you, Angel.
That would be the items we found in the gun on scene, and this was the gun that was found in the wooded area.
And so the cartridge case is the round that had been, is the case that had been fired?
Yes.
Okay, so that's number 2. All right, I can't remember, did we already read that line? Exhibit 2 cartridge case?
Yes.
Okay, thank you. Will you also look at or read the last paragraph on this page?
Yes. The Exhibit 2 cartridge case and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge case and Exhibit 3 cartridges, in parentheses scribe marks, that are consistent with being produced by engravings and or rotary cutting tips commonly found.
Let's scroll down, please, Kimberly.
Installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison if a suspect tool is located.
Okay. I'd ask to scroll back up to show the exhibit list. Number 6. What is Exhibit 6?
Exhibit 6 is the bullet fragment, the bullet jacket fragment, as well as some other fragments that were recovered from Mr. Kirk at the time of autopsy.
There you go.
Thank you. Going back to page 2, will you read the first full paragraph there, beginning with Exhibit 6?
Yes. Exhibit 6 consists of one .30 caliber class deformed damaged bullet jacket fragment and 4 lead fragments.
Will you read the next paragraph as well?
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
And if you'll look at the line starting with the Exhibit 6B through 6E, will you read that sentence as well?
The Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison.
Thank you. We can take Exhibit 32 down. Exhibit 33, if we can show that just to the witness, please.
Hey guys, by the way,
You recognize Exhibit 33?
hit subscribe button.
Yes.
What is
Thank
that?
y'all so much. Y'all have
This
gotten
is
me
an
so far.
ATF biology report on the Dremel tool as well as the cartridge cases that were found on top of the safe in Tyler's home.
Did you receive this from the ATF in response to your request for testing?
Yes, I did.
I move the admission of State's Exhibit 33.
No further objections, Your Honor.
Thank you, Mr. Burtz. Noting the standing objections by defense and level of publication, Mr. McBride.
All three levels.
Court overrules the standing objections and states Exhibit 33 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
What was being tested here?
The Dremel tool, the bits container, as well as the cartridges and cartridge casings we found in Tyler's home.
And up in the top right, it says forensic biology. Is this DNA testing?
Yes, it is.
Okay, format of this is the same as the other report that we already looked at, right?
Were they supposed to be
Let's jump
showing
to
this on
page
screen
4.
the whole time? Were they supposed to show us that?
Calculation
Because
number
that may have
one.
been... Did they skip over the bullet fragments?
It mentions here Exhibit 15.1. Do you know where that swab is from?
Yep, it is swabs of the buttons of the Dremel tool.
And will you read paragraph D?
Yes, the DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a contributor to the major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
We also read paragraph E.
The probability of an unrelated individual in the population who has not contributed DNA to this sample yielding this level of support is less than 1 in 1 trillion.
Thank you. I'm not going to ask you to read those paragraphs for the rest of the statistical calculations, but I will ask you to go through and identify where the swabbing came from. Exhibit 15.3, which is calculation number 2, where's that swab from?
As swabs of the cord of the Dremel tool.
Exhibit 15.5.
That would be swabs of the longest metal bit of the tool.
Going on to page 5. Calculation number 4, exhibit 15.6.
15.6 is swabs of the shortest metal bit.
And calculation number 5, 18.1.
This is swabs of 1 etched 30-06 cartridge case.
What is that? Where did that come from?
Are they purposely not showing that on
top of the
camera, I
safe.
guess?
Okay.
Why?
Is that the one that had the etching test shot?
Yes.
Will you read the paragraph D as it relates to the test shot swab?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 2
I'm a little
unrelated
confused 'cause
unknown
they've been showing all
individuals
sorts of
than if it
exhibits. They
originated
showed
from
the-
3 unrelated unknown
They showed
individuals.
the firearm, they showed everything else, but why not the fragments?
Thank you. We can take exhibit 33 down.
Why do they keep going away from the fragments but show
The
everything
final
else?
report is 34, if we can publish that just to the witness.
I'm confused.
What is State's Exhibit 34?
This is an ATF report I received that was comparing tool marks.
And is this, I move the admission of Plaintiff's Exhibit 34 and publication at all 3 levels.
Mr. Burt.
No further objections.
All right. And, all right, so State's Exhibit 34 is admitted. The objections, the standing objections by defense are overruled. They may be published in the courtroom and captured by the media camera.
I'm a little confused as to why the bullet jackets were and the fragments were
Okay.
not
Looking at
shown,
the exhibits,
but the cartridges were.
might have to go back and forth here,
What
but
was
let's
the-
go to
what
page
was the-
2.
I don't get it. Why?
And will you read the paragraph that starts with Exhibit 18 consists?
Yes. Exhibit 18 consists of 5 30-06 Springfield caliber fired cartridge cases, designated Exhibits 18A through 18E, and 15 45 auto caliber unfired cartridges, designated Exhibits 18F through 18T.
Okay. 18A, do you know what 18A is?
Yes, this would have been the 30-06 cartridge case with the engravings test
Yeah, they
shot
did show
on
that,
it.
didn't they?
Okay. Will you read the paragraph beginning with the Exhibit
Yeah,
18A?
screenshot that later.
The Exhibit 18A cartridge case was examined for the presence of comparable tool marks. Numerous sets of tool marks were located on the exterior of the Exhibit 18A cartridge case that are consistent with being produced by engravings and or rotary cutting tips commonly found installed in handheld rotary tools such as a Dremel tool. These tool marks contain marks of value for comparison.
Okay. The next paragraph I'd asked you to read is the one that starts with Exhibit 16. But first I want to ask you, do you know what Exhibit 16 is?
I do not, off the top of my head.
Okay. 18, it also says
You mean
Exhibit
Candace
18A
Owens?
through 18E. Do you know what those are?
Is that what you're talking about?
18A through 18E would be the cartridge cases that were found on top of the safe.
Okay. If you'll read paragraph, or that paragraph.
Which one again, sorry?
The one starting in Exhibit 16 and.
Yes. The Exhibit 16 and Exhibit 18A through 18E cartridge cases were identified as having been fired in the Exhibit 1 rifle.
Okay. Let's now jump to the paragraph beginning, the test tool marks. Kimberly, if you could scroll down. Will you please, well, first off, 15A and 15B, do you know what those are?
Yes, those would be the longest metal bit and then the shortest metal bit.
Okay. If you would read, okay, and then also Exhibits 2, the Exhibit 2 cartridge case, what is that?
This would have been the cartridge case that was found in the gun.
And Exhibits 3, 4, and 5 cartridges?
They were the ones also found in the gun.
And Exhibit 18A?
Is the one that was found on the safe.
Okay. If you'll read the first bullet point there, the Exhibit 15A.
Yes. The Exhibit 15A engraving cutter was identified as having made tool marks located on the Exhibit 2 cartridge case, Exhibit 3 through 5 cartridges, and Exhibit 18A cartridge case.
And will you, let's see. Okay. We can go ahead and take that down.
All right, not sure where we didn't show some of that stuff, but okay. What is this? What's this death look? What? Lady's like, who's she glaring at? Is that just her normal resting face? Here, oh, let me show you. Look at that. I don't know. I'm not sure what's going on there. That was interesting. Hilarious, though.
Your Honor, I want to, before I ask to enter my final line of questioning, I would like to show the witness Exhibit 12.1, and this is the video, the UVU surveillance video. Let's see, I think it's 12.4 was the surveillance video actually that was approved for publication.
That's correct. That's the unmarked, non-zoomed version, correct?
Is that correct? Yes.
Yes, that's the one that, yes.
And just for now, let's do this on the witness's screen.
Okay, let's see what they got.
12.4, and I'll ask you to jump to the 804 mark. Okay. I'd move to publish. We intend to play about 10 seconds of this video. I'd move to publish that at all 3 levels.
Mr. Burt?
I'm not sure what the relevance is at this point, so it's hard to object or not. I would ask for a proffer as to what it's showing, because it's not apparent from the exhibit.
Understood. Proffer is, there's been testimony about about prints being found on the glass window of this building. This exhibit demonstrates the suspect's behavior in that area.
All right. Anything further?
With that, I don't have any further objections.
All right. So it may be published. This is already admitted, and it may be published at all levels.
Hey, great seeing you, Vin. Thank you so much for being here, man.
Sergeant Falmuina, do you see what's on the screen in front of you?
Yes, I do.
Can you see the suspect in this image?
Yes.
Will you describe where that suspect is?
He's on the rooftop, let's say on the gravel part, and this would have been close to the northeast side of that building.
Timestamp is 12:23:47 p.m., is that right?
Yes.
And
All right.
that portion of the image that we see there, the video, is the top portion of the image slightly to the left of center, is that right?
Yes.
Okay, we're at 8:01. Kimberly, will you please hit play there?
Goes. Here. Right there, right now. He's climbing down. Looped. Bam.
Let's go ahead and pause it. Pausing it at 8:20. Were you able to determine if the suspect touched the glass when he dropped from the roof?
Not at the time when we first saw the video, no.
Okay. Were you later able
They
to
did
make
not
any
disclose the
determination on
grain.
that?
Yes, because the video we had was pretty grainy at the time on at the command post, and it wasn't
Weird.
until we're actually able to get the
Grainy?
footage
Grain?
directly from UVU.
And when you actually got that footage, could you zoom in and get a better picture?
Yes.
And were you able to determine at that time whether the suspect touched the window?
Yes.
What was your determination?
We determined that he was not, or he did not touch it.
Thank you. Nothing else.
All right. Let's go to a break. To defense, I realize that you began talking about your concerns. You have a witness that needs to leave today. 10, 15 minutes, what's your request? I want to maximize your ability to have time with your witnesses as well as cross if you choose to.
Just 10 minutes would be fine.
All right, let's break for 10 minutes and then come back and cross-examination.
Alrighty, that sounds good. I'm gonna take a quick bathroom break because I have not taken one yet. That's this live stream here. I stay here throughout the whole. I'll suffer through it. Not really. Alrighty. I'll be right back. Okay, guys. All right. There we go. So. Heck yeah. Made it back before they did. Oh, presiding Judge Artie. Yeah, right. Oh, looky, Judge Artie. However they say that crap. Has to be British, though. Yeah. Yeah. Farty trolls. More like farty holes. Because that is what it is for. Let's see. Charlie should still be here. This is also wrong. 1,000,000% agree. He should still be here. And people shouldn't be trying to profit off of his death. Yet, here we are. Here we are. It's really irritating. Man, okay. Yep. I don't understand this response. Wait. Oh, okay. He's here. Yeah. That is funny. Yeah, that's pretty good. Yeah, he's showing the height. Obviously, he's taller than that. Okay. It's just without context. It's like, I don't know. Same here. Look at the markings. Yeah. It's funny. I don't know. It's a very funny pick. It's just all of it's pretty funny. It'll make so much more sense when I do the video on it tomorrow, guys. That'll be a lot of fun. So anyway, how's everyone doing today, though? How is everybody? Before we get back to all this, let's see what Candace Owens is doing. How are you crashing out right now, Candace? Let's see. The police just took a picture of Lance's phone, guys. Biggest... Okay. Ridiculous. Did we even have phones during JFK? No? Okay. Just trusted him. Like, this is... Like... This Owens crashing out of... And she cannot even show proof. Just insane. Insane. She's complaining about this. This is this is better than what Candace Owens has provided. By far. Much better than what Candace Owens has provided. And yet she's complaining? Like, it's insane. It's pure insanity. Pure insanity. Lance Twigg said he never heard Tyler talk about Charlie or LGBTQ issues. But we're supposed to believe he jumped up one day and decided, oh, God dang, Candace. Like, what? Okay, so nobody's ever been ended by a exploding microphone before. So you want me to just believe that for some reason, Charlie Kirk's company just decided to stick a bomb in a microphone and blow him up in front of people? Like, all of Candace Owens' arguments can be argued back the exact same way in the opposite direction. So there's that. Oh, yeah, 72 inches is 6 foot even. Yeah, 60 inches would be 5 foot even. 60 plus 12 inches in, 72. And then it would be 84 for 7 feet. 96 for 8 feet. I'm not doing the math for 10 feet. Just no thanks. It would be 120 inches, right? For 10 feet. Because it would just be adding the 0 at the end. Yeah, never mind. I don't have to do math for that. You don't have to do math. You just got to know the tens. The table of tens. Well, she's crashing out. This is bad for her. It's so bad for her. No wonder she didn't live stream this. No wonder she didn't live stream this, because she would have been shredded. She would have been ripped apart by her own audience. There's just no getting around it. Let's see. Yep. All right. Good. Let's see where this is kind of going. Able to read. Oh, wait. Is she talking to her or me? Oh, me. Okay. Read the second image. It's like, it's just so hard. It's just so hard. It's just so hard to read, I guess. Okay. Just great. It's just crazy. Like, these people can't read at all. There's no public record of Charlie using the word any of these words. And it's just like, you expect me to believe that Charlie Kirk, for the first time ever, said the F word. First time ever. This is it. This is how it gets revealed that he cussed. Of all things, that just ridiculous, you know. Just crazy. Watch how Candace Owens painted an overblown picture, claiming over and over that Tyler Robinson would have to be Spider-Man to... Yeah, exactly. It is ridiculous, isn't it? DNA found on the firearm and cartridges allegedly used to end Charlie Kirk overwhelmingly likely belong to Tyler Robinson, forensic report. Correct. Charlie Kirk was alive today to respond to all the claims Candace Owens is making about his assassination. What would he say to her? Candace, if I were alive today, sitting across from you speaking, let's see. Stop, just stop. Yeah. It's interesting, but AI isn't real. It's not really even AI. So, yeah. Cool. Well, I don't have to take a screenshot of that now. It's just there. Lance Twiggs was transitioning to Luna. Yeah. And this is from September 13th, 2025. Well, why is this back up, though?
Court is back in session. Noting the presence of all parties, we just ended with a direct examination of the sergeant. Turning to defense, Mr. Burt,
Thank you.
witness.
Good afternoon.
Name's Turning Stiff?
Your role in the case was kind of as the traffic manager of the whole operation, right?
That's a good way to put it, yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
Your agency, if I'm correct, wrote a massive report, 229 pages long.
Yes.
You've read that? You're familiar with it?
With most of them, yes.
Okay. And it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you performed in this case?
Yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does that sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes, correct?
Yes.
And there were various crime scenes that you've described on direct examination, correct?
Yes.
One of them was the Fulton Library.
Yes.
tell us why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they're also trying to see, right, the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area, and so to them, they thought it was suspicious.
And were certain items seized from, and what were they?
Yes, you had a backpack, a jacket, as well as some gloves, and there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing?
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Was a decision at some time made, and you were requesting that both DNA and other type of analysis get done?
Yes.
At some point, did you decide to pull a plug on that?
At the time when it was already sent, we didn't have more information as far as whether or not the evidence that were collected there were probative.
But eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay. I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see,
I think his wording
that
was
you
bad.
wrote, was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents the NIBIN request for firearms.
Yes, so that was the request to conduct. What that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the
no
ATF,
chance this goes into
and
next
that
week.
is where we test
I
or
think
we
the bullets
input
and being in
test
his house
fires
was
or
enough
cartridge
evidence.
casings, the head stamps,
So the
and
judge will
whatnot
rule.
into a machine that is then run.
We'll
through
see
the
his ruling at
ATF,
about 6 o'clock tonight,
to see if there's
Central.
any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now, going back for a minute to the crime scenes, you talked about the wooded area, and you used the phrase, "we seized the towel." Who is we? Who are you referring to when you say "we seized the towel"?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say "we seized the towel," what you really mean is she seized the towel and you observed her seize it.
Oh, you really got her on this
when
one,
she
buddy.
sees a towel, can you describe a little bit more detail of how that process took place?
As far as when it was found or when she removed it?
Yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all you got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then, I guess, put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes. It wasn't over it. It was still wrapped around the gun.
Okay, but as I understood your testimony, the towel was seized by the FBI agent, and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun
They
was
left it
wrapped in the towel. So when Special Agent Kamak reached
Pay
in,
attention.
she grabbed not only the towel but also the gun, and it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier.
Correct.
Once we documented that, and then the towel was removed from the gun.
You also mentioned as to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yep, I was involved in coordinating all that and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items? Or are we talking about something else?
Talking about something else.
And what is that something else?
So after the teams would have packaged all the items, sealed them properly, create an evidence log, they would then bring it back to the command post, and from there, we would compile everything, and then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof?
Correct.
And who were the people who were actually conducting that part of the crime scene processing?
That would have been our state crime lab, those two people are part of our state crime lab's crime scene response team.
When did you review the video of the suspect running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been the day on September 10th.
You saw that on September 10th?
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lifts were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one
So in other words, she was partially there.
report dated September 24th,
What's she trying to
documenting
get at,
the
though?
forensic
Are they just trying to
analysis
discredit the
as of
witness? Is that
September
it?
24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was
Yeah, he really should have been
again
paying
about
attention.
the
I was playing
crime scene
guitar and I listened to her perfectly.
progress of the forensic testing, right?
It's not hard
Yes.
to pay attention.
Right. And then you have a report here
J
which
2010, what does it matter
documents
whether she was present or not?
a
I don't think it
firearm
does
trace
matter.
and a firearm seized at
Honestly, I don't.
River Street.
Yes.
Nothing of value came of that, correct?
Correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, or it's not SBI, it's actually the state crime lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed,
Yes.
right? You have a report documenting the transfer of evidence from the FBI to your department.
Yes.
And then the last one that I have that you personally wrote has to do with again, summarizing forensic reports.
Yes.
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some of this documents in that
Bro,
large
did you do
report
your
indicates
research?
that your agency has also, up to the present time, been monitoring Mr. Robinson's mail and communications at the jail. Correct?
Correct?
And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Thank you, Mr. Byrd. Redirect.
That was a waste of time.
All right, may this witness be excused? All right, Sergeant, thank you.
Thank you.
Okay.
Turning to the state.
Your Honor, I just want to.
I don't understand those line of questions, to be honest.
Yeah, let's make sure. Thank you, Mr. Gernander. Appreciate creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm wrong. I have State's Exhibit 1, 2, 3, 3.1, 3.2, 4, 5, 5.16, 6.17, 7.18, 8.19, 10, 10.1, 10.2, 10.3, 11, 12.1, 12.2, 12.3, and I believe 12.4.
Yeah.
13, 14, 15, 16, 16.1, 16.2, 16.3, 16.4, 17 and 18 are blank, so no.
That is
19
correct.
All right.
We're not offering 17 and 18.
All right. 19, 20, 21, 22, 23, 24, 25. The following are blank, 26, 27, 28, 29.
That's accurate. We're not offering on those numbers.
I have 30, 31, 32, 33, 34, and 35, which have been admitted into evidence.
That is all that I have record of.
All right.
Can I
Does that comport?
Yes, can we also go over the ones that were
The grid says the medical report.
I mean, we certainly can. Yes, would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right.
Can I have just a moment?
Yes.
All right, I guess we'll see what happens here. So, Grits, it should be the medical examiner's report coming up. Hopefully that's the case.
Your Honor, the state rests its case in chief.
Thank you.
Oh. Oh.
Turning to defense.
Okay.
Approach the bench, please.
What do we got? Oh, they were just talking about the previous witness. Never mind. If I had to guess. I guess that guy's line of questions would have been good if he was paying attention and paid attention to what it was that the lady on the stand was doing. Because he thought she was a part of a couple other things that she wasn't a part of. So I guess that probably hurt the defense more than anything. That was a really dumb mistake. So, I don't know. It would have made sense if she did do the stuff that they thought she had done. And if they would have got her on some gotchas, but unfortunately, they just did not do their homework good enough. Let's see. Let's go to check some of the notifications. Oh, hey, checks on the right. Yay. I retweeted this. Oh, they retweeted my retweet of this retweet. It was a triple tweet. A triple tweet. Okay, here we go. Anything? Nope. No. This it? Yep, 2 hours ago. Yeah, she's
Get
off
situated.
partying.
All right, counsel, your request.
Your Honor, as the court knows, the family has asked that all exhibits admitted into evidence be shown here in open court. We are grateful to the court for allowing the family to view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. we think that we ask the court that since the court's considering it, that the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies, that's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justices said in
It's for the
Estes
family.
case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to
They want to
educate
see
the
the
public or
film.
the
I think
victim's
the family
or
has the
world
right.
on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that, but at some point, I think the court has to return to the purpose of these hearings, which is
Third parties?
expeditiously hear the evidence and then determine probable cause.
Does Erica Kirk sound like a third
And
party
I
in
want to
this
point out
court?
to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public
I
domain.
wouldn't throw Erica Kirk
So
under
they're
the bus,
perfectly
buddy.
free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose
I'll pull that
of
up,
informing the world or
Candace's new
Ms.
video?
Kirk or anybody else, that the court
Her
do it at
latest
the
YouTube
end of
video?
the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Byrd.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in a spot where we need to be. And I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family's not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense? No. All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights.
Do they?
And as has been
We'll find
previously
out.
stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have,
We have court tomorrow?
an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that that cannot happen, but for today,
I thought it was supposed to
we
just
need
go
to
to
focus
today.
on this.
Guess I gotta change my thumbnail.
To getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no. I'm simply saying we need to get to this witness and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right. Samantha Carner is being requested. If you can go ahead and retrieve her.
Yes.
Bring her into the courtroom.
Someone is doing that.
Is somebody grabbing her?
Yes.
Okay, thank you, Mr. Burt. I just couldn't tell and wanted to make sure. All right, Ms. Carter, if you wouldn't mind coming forward, right by our bailiff to be sworn in.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You can sit.
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind
Thing looks
pulling
like a
that
freaking
microphone
border
toward
shell.
you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carner.
And Ms. Carner, what do you do for a living?
I am a firearm and tool mark examiner.
And
All right, here we
where
go.
are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the Firearm and Tool Mark Unit, so I receive items of evidence related to firearms, tools, tool marks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think approved.
All right,
for
let's go ahead and
publication.
put it on all screens because this was admitted and published previously. All right.
You recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the Submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges, and then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page.
Can't say anything about their water being
Those
in
2
it.
paragraphs,
Objection.
please.
It's good.
Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes.
Is this the ATS?
Well, why didn't you let me know?
Is this a language referred to in your report?
It is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm tool mark discipline pattern examination?
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
Gotta say, her,
Right, and
like,
what level of
she looks like she
publication
just
are
rolled
you
out of bed.
requesting, Mr. Birds?
Both public and admittance into evidence.
To this date?
No objection.
All right. Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that? Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm tool mark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm.
Mm-hmm.
But that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says, an examiner shall not assert that examinations conducted in the forensic firearms toolmark discipline are infallible. You're not asserting that?
I am not, no.
You're not asserting that, it says the examiner shall not assert that there is a 0 error rate. You're not
Correct.
making that assertion,
No.
okay? Says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says, an examiner shall not cite the number of examinations conducted in the forensic firearm toolmark discipline performed in his or her career as a direct measure
Man, this
for
sucks,
the
like-
accuracy of a conclusion provided.
I hate going over company
You
policy.
didn't do that, and you're not doing that here.
And that's all this is.
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could
And why
you
did you do
display
that
to
in
her alone, please, Exhibit
The cases were in the case.
6, Carner 6? Case file. Yes.
Oh, it's like
Do you see
snap
what's
something.
displayed there?
Yeah, I
I
thought he
do,
went.
yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then, yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence?
To the state.
Is this the 47-page document?
Yes.
I object. I don't see the relevance to the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burt?
Yes, Your Honor, this is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right. Anything further?
No?
Yes, just that without testimony about what the meaning of the notes is and so forth, it is
Yeah,
more
sorry, I'm a
confusing than
little
it is
tired today,
probative.
guys. I'm normally
so under
more
a
vocal.
403 analysis, I don't think it's admissible nor helpful to the court.
All right. Mr. Burt?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as
the
well as
defense
State's
gotta
Exhibit
win.
32, which is admitted, and the state is
I don't really
able to
care
do
about this,
cross-examination
though.
on
Okay.
this witness as it relates to this report. And so it is
She'll just
admitted and
explain
may
it
be
in court.
published on all levels.
So now she's going to have to come back and explain it in the trial
through
when
the
it comes
media.
up.
Thank you.
Wow.
Ms. Carter, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay. Could you display page 41 of 47, that exhibit?
Could be trying
sorry,
to say the
page
evidence she
14.
received was not the same evidence. We'll see. I could use something like a coffee,
And
for sure.
tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through
I
6E in descending order. And then the bottom 2 photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo,
You know how
the
peeling
petals
works?
have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the
Tweezers.
portions that you want to look at?
I use pliers.
Okay.
Close enough.
And after you
Giant
did that procedure, did you then photograph the
Finally got the
larger bullet
fragments though, huh?
fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is 2 pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics?
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that
You want a fancy
characterize them
Belgian beer?
together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on and looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been a certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
Within a 30 caliber.
The range of the diameter for the 6A bullet jacket fragment was .286 to .301 inches.
Okay, what page are you looking at?
It's page 13.
Okay.
Oh, if you want a good Belgian beer, Chimay Blue.
So this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width, correct?
The land impression width, yes.
And these are all general characteristics, or class characteristics, right?
Correct.
Okay. Now, once you had that and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning.
6 right, yes.
Yeah. And that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle, so it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all-inclusive. It is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different .30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or?
Correct.
And what is RB?
Bolt action.
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet?
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now, let's go back to the examination of the other two measures,
This guy just
subclass
slowly-
characteristics
He's like,
and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics?
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be
harrowing.
similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present, and they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes?
Yes, please.
My subclass assessment that's on page 13 of my report states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The striae observed are not coarse, I think I understand that, and vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and tool mark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say, if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic. Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris?
I think it says dust, so I would say dust.
Dust. What can cause dust to get inside of a barrel?
A plethora of things. I'm not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes.
Then the next part of the examination was
Hey, thank you, Brusha.
determining whether you had any individual characteristics on the bullet, correct?
Yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison or, yes, individual characteristics in the landing groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
And each one of those
How
bullets
many
is like
test fires
$1,000
did you,
too.
produce in this
Ridiculous.
case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case
I
that
see
this
where our
particular
tax dollars are
weapon
going.
was
Those bullets are
manufactured in
expensive,
Germany
the
in
test bullets.
1938?
I was
You guys
not,
should see
no.
the factory that makes them.
You did not review
They make
a
expensive
report
peanut
from
butter,
an
too.
ATF agent who
And other
investigated
things like that.
issue?
It's wild.
No, I don't believe so, no.
In doing
Like
your
$700
examinations,
a
is it
jar of
important
peanut butter.
to know something about the manufacturing process of
I'll
the-
explain that
of the
later.
weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if a item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are at times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on 2 separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired, and when you start comparing them, you will see differences between each bullet.
There is a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining two or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay. And what is AFTI?
AFTI is the Association of Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer-reviewed published journal. Can I join AFTI?
You can, most of the firearms community, or excuse me, members are firearm and toolmark examiners. There are also technical advisors and associate members. Those members are not usually firearm and toolmark examiners, but they still have a livelihood in firearm and toolmark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
You just have to pay the fee. Okay. Could you display to the witness Exhibit 27, please?
Hey, congrats there, Mr. Jones.
Do you
Glad to hear that.
recognize what's displayed here?
It appears to be the AFTI theory of
Hey,
identification.
Kenneth Woody, I appreciate you
Move
being
that
here,
into
man.
evidence, Your Honor.
You have a good night.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
to the state?
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right.
Sure.
Let's go ahead and do so, Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Mr. Byrd.
Does this document accurately state what the theory is?
May I take a moment to read through
Yeah,
it?
sure.
I believe something, I think the first statement is different than what I can recall, but overall, it is what the AFTI theory states.
Okay. And your ATF protocol refers specifically to the AFTI theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions.
Sorry,
Page
saying bye to the
103.
kids and
I don't
Mama.
have a
They're going
base
to
on it.
do stuff real quick.
Toward the end. It's document FT 10.
Man,
No, that's not it.
this is a much more fruitful hearing. Today's hearing was anyway. But man, the ending is brutal.
Could I approach a witness, Your Honor?
You may.
Page 1 of 3 of your protocol. I think what it's-
Hey, Angel May, thank you for being
I
here.
recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFTI theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Oh, yeah, they just showed it like a few
Language
minutes
matters. Without knowing what, if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles, and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
Mr. Burke.
Goes to weight, not admissibility. You'd be free to question her about any differences, but I think she's laid a foundation that the theory's the same, so.
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you, I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Carner 27?
Yes.
Is admitted and may be
Thank you.
published.
Yeah, fair enough. This isn't really enough to even shake the foundation of this. I mean, for the purpose of this trial, they're just trying to see,
Looking at the
like,
language
they are
of this, the
trying to
second
get
part of it, according to AFTI,
no
says,
trial.
currently the
Prosecution wants it to
interpretation
go to
of
trial.
individualization, identification
We've already got more than
is
enough evidence now.
subjective
I don't know what we're
in
doing.
nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And, no, wait a minute, go back if you would. But while he's doing that, does your manual state, what you're looking for under this theory is correspondence of individual
Oh, do you have a
characteristics?
whistle list?
Yes.
That, the
A list?
theory is that if you see a certain level of correspondence, you
Lamps,
can
twigs.
make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is the subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't. May I be heard?
If you're objecting, I will hear the objection.
It's just speaking objection. That's why I stopped myself. This goes to weight. This goes to credibility. And the witness's report has already been admitted as is appropriate under the Utah Constitution, Rule 7B and Rule 1102 of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burt.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this, pre-hearing interview with this witness where these same questions were asked. We had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
All right. Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Okay. Well,
what happens.
In regards to whether objections have been waived or not, the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it
Sure.
to the probable cause. I'm not trying to limit what your theories or such, but I need to hold to probable cause.
Absolutely, and I don't even need a quarter of a mile. This is my last question, and I'm going to move to another topic.
Thank you, Mr. Burt.
Is that what your manual states?
I don't remember it verbatim, but
Hopefully
it
this is the
does
last
sound
question.
accurate.
We'll see.
Well, could you pull up Exhibit 12, page? Just to, can I approach again?
You may.
I'll give you the 2 pages. Bottom of the page, highlighted.
I see where you were reading from, yes.
Do you see?
Yes,
Did I accurately read it?
I believe so, yes.
Thank you.
There you go.
Can I approach again?
You may.
Okay. Now let's return to the report, the People's or State 32. And if you would go to the second page, please. You concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The result of the comparison was inconclusive.
Yes.
That was your ultimate conclusion, right?
Yes.
And on the next page, if you go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you because I'm unclear on what inconclusive mean. You say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There is a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the landing group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see at all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay. I think you and I have met before today, correct?
Yes.
Where we talked about what that term inconclusive meant, correct?
Yes.
And I think, and correct me if I'm wrong, but did I read to you from a do you recall me asking you whether you agreed with this statement, that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay. So I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is the 47-page document. There we go. What's the tab? 6. Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to
Boy, we're going down 100 miles, aren't we?
page 37.
This guy always has only one last question, almost always.
Is the top photo depicting one test fire on the left and another test fire from the same gun on the right?
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion,
About
using
all of
this subjective theory of identification, what
Definitely this specific line
show
here.
us what you're looking at?
Is it touchscreen?
Probably
No, it's not.
no.
I'm sorry.
But we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right. So that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up. Keep going. There you go. You have a line that was right there, and you have several
hard.
others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these two bullets, right?
Yes, and the purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are
Yeah,
reproduced.
it was 2 days ago, and the
Okay,
judge
so
did
go to
let
the
it
photo on the bottom of that page.
Okay.
This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean, blue index GIMP?
So that will be, the first number there is the
using
case
GIMP,
number,
really?
the laboratory case number. Then next, 1.11B is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for groove impression, so I'm looking at a
never mind.
groove impression in this photo.
It's
Blue
not the
index
program.
means I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at, and then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those two highlighted lines near the top, there is a lot of damage that is observed, and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement, and specifically talking about those two highlighted lines at the top on the right.
Okay.
We're going to be looking at this.
Go to the next
We're gonna
page,
be
please.
looking right here.
Top photo on the next page. It's B38.
Okay.
You see areas of disagreement in this photo.
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at
see
those
this
two
one
highlighted lines
there.
near the top. And then if you look down, you can almost see that damage a little bit better. And
I
there's
can't
none
tell
of
if
those
that's one or not.
striated lines that you see on the test fire, which you would expect to see
I don't
in
know
a
if I see
lander
any more
groove
than this.
impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
Possibly
How
this,
about
but
the
that could
bottom
just be
photo?
manufacturer.
And again, the question, areas of disagreement.
Several agreement. Boom, boom, boom.
The possibility of an area of disagreement maybe in the middle. There on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this
Very much
photo, it
agreement
does
on
not
the
look like
top.
it does, though.
Okay.
So, if I had to
And
guess,
could you
I'm not
go
an
to the
expert.
next photo, please?
So, my word means nothing. But at the top, that one was probably the best one. So several agreement at that bottom one. Holy cow. We're not going to go to the bottom one yet, though, are we?
Same question here. Areas of disagreement.
Why not
The way
agreement?
this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, you don't see the line on the right going all the way over. But again, this is just a snapshot of one particular area.
Doesn't show areas
Lots
of
of
agreement or
agreement down here, though.
disagreement.
There is an area of agreement at the very bottom of the photo.
Yeah, I could be an expert at this. What do
Okay.
you know?
Correct, yes.
Next photo, please.
What do you know? I guess it ain't that tough after all. Lots of agreement in this bottom photo, though. Lots. Just all throughout.
How about
But
this
this
one?
is also probably zoomed
This
in a
is
lot.
another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30x to 40x and just highlighting one specific area, and this is showing you agreement.
I mean, it's all of
Next
it, too.
photo.
It's every single line. That's a pretty strong one. But it's also cherry picking. So I understand why she gave that little caveat. For sure. I say little. It's quite the caveat. It's a big caveat. This one, I don't... Well, I see some here.
So again, this area that is highlighted, the bottom portion
Right
that's
here.
in focus, is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet
they're really
jacket
hard to
fragment,
see.
so it's hard to say if that area was an agreement or
nothing here.
disagreement. That's not what my photo was focusing on.
All right.
So one
Next one.
here, one there, yeah. Then it just blurs out at that top. Or it's not really blurry. It's just like light reflected. I don't see any agreement on this.
So again, this
Oh,
is going to show you part of the
No.
groove impression at the white index. On the top, you can see some striated lines,
Maybe
excuse me,
here?
more of the middle of the photo. The top of the groove impression from the 6A, you see some lines do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you
like
can't
quite a
look at
few
the
areas of
entirety of the
agreement.
land in this moment.
This
Now
bottom
this,
one's going to have
you can
the
take
top-
that down, please.
I don't understand the bottom.
Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have
Yeah,
heard,
but Leanna,
yes,
she
I've
knew her
heard
stuff.
recommendations on how to
It
improve the
didn't
AFTE
matter.
theory of identification, yes.
It didn't matter. She
Well,
she
the
killed it.
criticism have gone beyond that, right?
But it is scummy. I'll give you that
Specifically,
for
what are you
sure.
referring to?
Well, you're aware that the National Resource, the National Resource Council,
The National Academy of Science?
National Academy of Science,
Yes,
is that a pretty preeminent scientific organization in this country?
yes.
Did they conclude in 2009 that, quote, a fundamental problem with tool mark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTE document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection,
there's.
objection. We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing and beyond the scope of the PC hearing, as I previously objected.
I think it goes directly to reliability. That a scientific group studied this exact process that she used in this case and reached that conclusion.
Oh, Xander.
If you would,
Candace
so-
will come up with a million excuses.
Again,
won't she?
I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009.
Right.
And so we're in 2026. And again,
Right.
I don't want to have to dive deep into areas trying to determine, because I
because
feel
obviously,
that we are exiting the
if there was a study that came out in
the
2020
orbit
about
of probable cause.
That
If I'm
makes
having
sense.
to make that analysis and trying to see, like, how is this relevant? How does this apply?
Yeah,
how does
because
this
you're
go
asking
to
this
probable
lady
cause? So if
to
you wish
keep
to
up
ask
with
this question and then move on, we certainly could do
years
that.
ago.
But
Sure. The only thing I
not
wanted to
27,
do was
yeah.
establish that this was the foundation criticism in 2009.
17
And I
years
know
ago.
when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten
they?
more strident. So I think that's the take-home here, is that this is not some past criticism
any
that
recent
has
study
been
on this
set
specific?
aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you, because what I have is what's before me. I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree, and I was offering that to the court as a proffer in
Okay.
terms of where this line of questioning is going, so the court can understand the context.
Okay.
It isn't just an isolated criticism, and I'll establish with a couple
Well,
of
then
questions
get us a newer study.
that it's continued up to the present time.
So I will
newer
overrule
study-
the objection, but I will limit you to this question. We're going to more and more and more. I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burke.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016?
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question and then we're moving on, because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
And I
thought-
apologize if I wasn't clear on that, so maybe it was my error not communicating. I've accepted
was pretty
that
clear.
coming in. I've overruled the objection, but I said we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one? If that's,
On this line of question, that's correct. Because
Okay.
Thank you,
All right.
Mr. Burke.
and I think I've made the proffer in terms of the relevancy of it. The
And
court is-
I accept that, so thank you, Mr. Burke.
Right.
Right. Then the last area is, in the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
Oh, this isn't Novak, I don't think.
I don't
Novak's
remember the
super
exact year,
curly
but
hair
that
guy,
sounds
right?
correct, yes.
Am I wrong about that?
And is it true that
I mean, he's
that
on Novak's team.
proficiency
Is
test
this Novak?
involved a
That was
test
like Mr.
where
Burr or something like that.
you had question bullets, and then you had two sets of bullets, one that
Started
was
with a
fired
B.
from
I
one
can't
gun,
remember.
not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
I think when you and I talked about this, you said you're aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the correct answer was that the bullets did not come from the question, the two did not match, the known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by 2 separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26?
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
This is my last question. So.
All right, Mr. Britt. Thank
Is
you,
it?
Mr. McBride.
I bet it's not
Appreciate
your
that-
last
that
question.
heads up.
In your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure, is this also?
It has not been admitted, and
Okay.
I'm asking this question and as a foundation for admitting it.
Okay, that's fine. So I just
Yeah.
want, it was on another screen. I wanted clarification, so it's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
All right.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Oh, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28.
Yeah, just based on today's, honestly, today's
28,
court
page
case,
28.
I don't see why he doesn't make a ruling today, to be honest. Because there's more than enough probable cause.
Exhibit 19, page 28.
There's witness, there's the fact that they had the 30-06 bullets with the carvings in it, the Dremel tool and all that. That stuff right there is more than enough. I
Same
don't know that
question.
we need anything else.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all 3 of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
All right. Mr. McBride.
All right, here's the cross-examination.
Good afternoon.
Good afternoon.
Those last 3 photos that you were shown, had you seen those before?
I had looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Of some sort?
Yes. It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay.
It happens.
And when you do an examination or a comparison, are you limited to one photograph?
No,
You actually have the item in front of you, correct?
that is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison. Is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land,
Jan
every
getting
single
the,
groove
party
impression,
started today,
and
huh?
doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of 2 bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices, and I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
She made
How
the
long did
exploding
you have that
microphone.
position?
I think cumulatively it was about 5 to 6 years.
Go, Candace.
And
Spin it.
before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes, so part of becoming a firearm and toolmark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. In phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms using a comparison microscope comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTI's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTI. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTI especially takes those recommendations very seriously. If the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are there principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I may have some news for you guys.
Draw your attention to Plaintiff's Exhibit
We'll have to
32.
see in a second.
Thank you.
Once this court wraps up, we're going to have to go back to the evidence. I think they showed a box of ammunition, maybe. If it's a core lock, there's no way it was going through Charlie.
Well, that's pulling up. And this has been published, it's been approved for publication at all 3 levels already, so we can put that on the screens. Well, that's pulling up.
There may be a picture of the
I want to ask you
box
first
of ammo,
about
so we
an
need to go
entry
back to
here.
it.
The second
think it was a
sentence
core
under
lock.
results of examination.
Which means it was
Exhibit
hollow.
1 rifle was test fired and found
Soft
to be in
tip.
operable condition. Did you
In other
perform
words,
that
when it
test
hits-
fire?
I did, yes.
It would have fragmented.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Instead of those.
Yes, it did.
imaginative science.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibered for. In this place, it was 30-06 Springfield, load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why do you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The
keeps it
water
from
is going to
smashing.
slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
And that the evidence rounds that you, or in the bullets that you often receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damaged bullets, yes.
In this circumstance, the Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case. Let's see here.
This is the prosecution. Cross-examined. By the way. They did show the box of bullets. I guess I missed it somehow. I don't know how I missed
If you'll
it.
turn to page 2.
Because I was very vigilant looking for a box
And
of ammunition.
we've already read this line. I think defense counsel
If it's core
read
locked, this
line
is
to you,
insane.
The Exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Well, they didn't do that. They should've.
Defense counsel put up a list of potential firearms that could have fired this round, or this bullet.
Yes, I can explain.
Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that
Essentially,
this round...
soft tip, they put a piece of polymer
I'll leave it
or
at that,
something at
actually.
the very tip to keep it from getting clogged. That way when it hits, it won't because whenever it tears through clothing, most hollow points will take a piece of clothing and put it in there, and it'll kind of prevent it
There's
from
been some
opening
discussion
up
about
and
a
fragments.
bullet, the 6A bullet jacket
So-
fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that
But
with
it
you?
is a bullet designed to split.
Yes. Yes, please, go ahead.
Like a full metal jacket's designed to punch through.
So this is a
This is designed to
demonstrative of a
fragment
bullet.
split.
So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead
Oh,
core.
she's got a
So when
bullet.
I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket.
I thought it was a
bullet
nuke.
jacket
I thought
fragment.
it was a mini nuke.
What does that mean that it's a
That's
fragment?
just like Fallout.
Fragment means I don't
Core
have
lock,
the
yeah.
entirety of that
LOC
jacket.
or LOKT?
And
The LOKT
can
or
you
C?
testify as to why you don't have that entirety?
No, I cannot.
Take a look at the spelling.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead
LOKT.
fragments?
Yep, core locked. Yeah.
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split, and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming
What's funny
from
is I
this
very
particular firearm?
specifically
Would you expect
remember
to be able to
core
make
lock.
that comparison?
I would not expect to see
You know who
any
said-
characteristics that would help me reach a
Let me
conclusion.
pause it. Do you know who famously well, I won't say famously, but do you know who specifically said if a core locked bullet was used, he could see that happening to Charlie Kirk? You want to know who? I'll show you who. I'll show you guys who
No.
said it.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
With that a little bit.
Ooh, sorry, guys.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
Maybe it'll say lock. Here it is. We'll play that after. This is going to be beautiful. Guaranteed. Fast forward to the silent.
Is there a potential that the testing you do can
How far behind am I now? Oh, I'm not.
destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled.
Yes. I think, if anything, that lends to a better comparison process. It is a very well-known practice amongst firearm and toolmark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. In reaching the conclusions that you did in this case, did you follow the protocols and practices that are required by your position?
I did, yes.
Nothing else?
Mr. Bird.
All right. Oh, great.
You said a couple of things of interest to me. One was that your work is peer-reviewed, right? There's a peer reviewer, a second reviewer?
It is a verification process.
Verification process. And you know, in this case, we requested to produce the case file from your reviewer so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an authored verification chart.
Well, you wrote a memo to Mr. McBride dated May 19th, did you not, in which you said in answer to our request for the reviewer's work product that ATF laboratories do not release materials concerning technical reviewers or verifiers.
Oh, that's
and
awesome,
you went on to
Chris.
state, did you not, that we don't even release the
Shout out
CVs
to
of
your
who
niece
the
doing this
reviewers
stuff.
are.
So that is not authored by me. That is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Objection argumentative.
Counsel?
Yeah. Duh.
It goes to the issue that was raised on cross-examination, which is my work was peer-reviewed. So how do we evaluate the strength of that assertion when they refuse to hand over to us the work product of the reviewers, or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative. Because we can look at the question, working in secret
Let me rephrase.
Okay, so I am going to sustain the objection. Because of the phrasing, it is inherently argumentative. It wouldn't be a question that would be able to proceed in the prelim.
Do you have an opinion on whether it is scientifically defensible to rely on a peer reviewer and not reveal that peer reviewer's work product?
I believe I understand what you're asking. However, in this case, the verifier does not have any work product to show. If you'd like to see their CV, I cannot testify to anything about the procedures of giving their information out. All I can say is that they are employed at my laboratory, are under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
They don't have any work product to show, but your protocol calls for, does it not, documentation of whatever it is they did.
And that is included in my case file.
That's what she said.
Right, but not,
You have
not
access
the
to it.
reviewer's work product.
The reviewer's work product is a verification sheet. If you'd like, I can
In her
refer to
case
my
file.
case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said
Pay
two
attention,
things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually, I think the recommendation was one more black box study to show the foundational validity of firearm tool mark examination, and since 2016, several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to measure validity and estimate reliability. The scientific criteria for foundational validity requires more than
Hey,
one
Bart.
such study to demonstrate
Hey, J27.
reproducibility.
I see you guys on
Isn't that
Rumble.
what they found?
That is what their finding was, correct.
Okay. And then after that report was published,
Thank you all
in
for being open.
2017, they came out with a second report because people said, oh, the literature already exists, you missed it. And they said, no, that's not true. Isn't that right?
They concluded,
Relevance to preliminary hearing. We're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Thank you. On cross-examination, that door was opened by the state, and so I will allow limited questioning on recross or redirect, however
Hey,
we want to
Gian Barry,
label this.
thanks
So
for
you may
joining as a
proceed.
troll.
The objection is overruled.
All right, let's hear this very limited
In 2017,
questions, supposedly.
they filed a second report
gonna be
responding
limited.
to assertions by people in your profession and others that they had missed or the studies had already been done. Isn't that true?
yes, PCAS did a 2017 addendum to their 2016 report, reiterating that they believe that the only way to properly empirically test a science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
And in response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes.
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
Which webinar are you referring to?
You attended a webinar, I believe, in 2023.
Boy, I'm glad we're talking about her webinar.
Treatment of inconclusive
Doing good, Bart,
results and
J2010.
error rates of
Thank y'all.
firearm studies. Webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021.
Correct, I did.
According to, and that group has published a number of studies right up to 2026. For instance, their study in 2024 called Methodological Problems in Every
Arrogant. That's
Black
cool, though.
Box Study of
You're on
Forensic
A&E?
Firearm Comparisons,
Yeah.
in which they concluded that the field still was not reliable despite the studies that you reference. Isn't that true?
That is the author's opinion, correct?
Right. And they're not the
Okay.
only ones. There have been other groups of statisticians who have published articles right up to 2026 saying that the studies that you referenced are unreliable. That their
Yes.
methodology of those studies is flawed and cannot be relied upon to support the science of tool mark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that,
This isn't bite mark analysis, which is terrible.
or it was brought out that you have
Y'all ever heard about bite mark analysis?
training and
That's a load of crap.
experience, right?
Correct, yes.
Bullets are not flesh,
you
though. They
agree
do not
with the
expand. They do not
conclusion
bleed. They do not
Stated
bruise.
in the
You know what I mean?
section of the report, the PCAP
Once the
report,
damage is there, it doesn't change.
that neither experience nor professional practices can substitute for foundational validity. Do you agree with that?
I do, yes.
You agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as the percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAS said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damage samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
But you would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right. Okay, thank you.
Thank you. Anything further for this witness? And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you opened the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
Yeah. I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer-reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
Just think of what that would mean.
May this witness be excused?
If
Mr.
they
Burt,
did
thank you, Mr.
discredit
McBride.
her,
Ma'am, thank you for being here.
how
You're
many
excused.
courts across the country would actually
Right.
have to
That
go back
brings us
and
to a
look at
close. Do either party wish the benefit
Redo
of the
their
record
trials.
before we adjourn for the night?
Not saying it's not necessary. Oh.
Yes, you may have that, and we'll stay in court for these 5 minutes, just because it would take longer to let everyone go and then come back in.
What's happening? I didn't hear her at all. She didn't have a microphone. So is it over? Yep. We're doing a backflip. I don't know what's happening. I'm not sure. Is this over? Because, like, they got 5 minutes for something. Here we go. We're going forward. Oh, okay. There we go. But what are we doing, guys? What are we doing? Ooh, could we get this to 30,100 right now? Maybe, I don't know. Everyone here's probably all subscribed. We'll see what happens. So I want to know what's going on real quick. Before I start trying to rewind this and go back to, where would that be? Somewhere around here. Got some ammunition. On the video. Where was that ammunition at?
We're live. So court is back in session.
Okay, so we are.
All
Good.
the parties are present,
Find this out.
except for maybe one attorney. Mr. Grunender, should we wait for counsel?
Take maybe 30 seconds to wait for Mr. McBride.
All right, we'll wait for Mr. McBride. I just want to ensure all the attorneys are present.
The bullets. That. Okay.
All right, I note the presence of all attorneys. Turning to Ms. Nestor.
Thank you, Your Honor. Your Honor, we have just one more witness who would be a fairly short witness, not super long. So I anticipate we will be done tomorrow, probably by lunch, I would think. So maybe if we could plan that we'll be finished. We probably will not need the entire day tomorrow, is my
I
suggestion.
don't see any box of ammunition.
Turning to the
I saw
state,
individual
obviously I'm not holding you to
How do we confirm?
your answer today, but just for guidance, does the state anticipate and rebuttal witnesses?
Judge, we don't anticipate any rebuttal evidence that needs to be presented to this hearing. So I think the question would be is, are we going to argue the bind over tomorrow? And the state would be prepared to argue bind over tomorrow.
All right, well, I appreciate that. In regards to trying to budget time here, how much time does the state anticipate? Obviously, there's one more witness, so I'm not going to.
If it's a short witness, Judge, I don't think it should take us the entire morning. But we would be prepared to argue tomorrow morning at the close of evidence or first thing in the afternoon.
And how much time do you anticipate that argument being? Again, a rough estimate. I'm not holding you to the exact number. I'm just trying to see how close are we to the 5 o'clock, because I'm going to ask the defense the same question as well.
It wouldn't come close to the 5 o'clock hour, Judge.
For just you or for both?
For argument?
Yes.
Both of us.
Okay. All right. Well, I'll turn it. Thank you, Mr.
If we have to argue 2 hours apiece for bind over, there's a problem.
All right. Thank you, Mr. Fernando.
Thank you.
To the defense, I'm just getting an estimate. I'm not holding you. I'm not going to time you to this, but I'm just trying to see as it relates to 5 o'clock and for argument for bind over tomorrow afternoon.
Understood, Your Honor. Our request, the defense request, is that we be allowed to submit briefing. There are some legal issues that we would like to brief for the court prior to the decision on the bind over. We're open to briefing, page limits, time limits, all of that, but we would like that opportunity because there are some legal complexities involved here.
All right. And if and I'm going to ask the state, but if the state, well, I'm not going to assume anything. Thank you. So
I believe the state is going to object to that, Your Honor.
So what I hear you saying is you wish to, well, I don't want to assume. What it seems like you're saying, and I want to be clear, is you're waiving oral argument and just doing briefing.
So generally, Your Honor, in cases with multiple counts that are pretty complex issues of law, I have asked for briefing and the opportunity for an argument. We can set time limits on that as well prior to bind over. I've done this in multiple other cases before courts in Utah. And that is my preference, to make sure we get the law right.
And so how much time, if you're asking for argument, that in addition to briefing, I'm trying to get the total universe of what's in front of me.
So I anticipate that, I agree with Mr. Grunander that I don't think an argument would take more than a half day. Should take less than that, particularly if we're briefing issues beforehand. So, I don't know, 2 hours for argument total?
I see what they're arguing now.
Thank you.
So instead of him going straight to
Turning
the
back
ruling
to the
tomorrow,
states, what is, you've heard from the defense.
Again, Judge, the state would prefer to argue tomorrow. We think the court has all the evidence before it and could make a bind-over decision after oral argument tomorrow. If the court decides that briefing is necessary, I believe the court reporter could have a transcript available as early as Monday of next week at an expedited, on an expedited request. With that said, each side would need, 2 weeks to. We're the moving party. We would prepare a motion in support of bind over. There would be a response and then a reply. So we're probably 6 weeks out before we can actually argue before bind over. We would rather not wait 6 weeks to argue bind over. That's why we would like to do it tomorrow. But that's the timeline we're probably looking at, is about 6 weeks and then 2 to 3 hours of argument.
So are you requesting to move forward with oral argument tomorrow and in addition to briefing? Or again, I'm just trying to see the whole universe that's before me.
Good question, Judge. If the court wants briefing, I don't believe we would argue tomorrow. We would save that argument until the briefing is finished.
All right. Thank you. And
Not sure
to
what's going on
defense,
yet.
would you agree on the time frame for briefing?
Hey, thank you, Cherokee
Has
Chick.
been proposed by Mr. Grunander to allow each side the appropriate time, taking into consideration a transcript which may or may not be needed by the parties.
Transcript?
We
Is that
are
something you get from a
also
doctor these
okay
days?
with simultaneous briefing on this if the state prefers that. That wouldn't take 6 weeks if that's the concern, but we have no objection to the 6 weeks.
All right. And does your client waive any speedy trial rights that may result as this request? I just want to make sure I'm addressing constitutional rights. Also going to be addressing from the victim representative. This goes squarely into the victim's rights to speedy disposition. So again, I'm just trying to take it, and I know we're late. I just want to cover all these bases.
Yes, our client will waive his right, his speedy trial rights, so that we can properly brief the preliminary hearing issues.
So he's waiving his speedy trial?
To the state.
If the court wants briefing, we would not like to do simultaneous briefing. We would like to start it out as the moving party. The defense would then respond. We would then have the opportunity to reply before oral argument.
All right, and I'll invite Ms. Kirk's attorney if you wish to be heard. This goes squarely into the victim's rights as recognized in the Utah Constitution as well as the Utah statute as it's what's before us.
Okay. Moving forward to speedy trial.
Your Honor, obviously we want swift justice for Charlie here. I think we obviously know the court needs to make sure they're balancing all interests here, but I think as soon as the matter could be bound over and this matter could be set for trial, that's what the Kirk family would like.
But do you want to weigh in regards to briefing? Because it sounds like it's...
Your Honor, I'm hesitant to weigh in on briefing. I feel as if that is a decision which the court should decide whether or not it's necessary, and we're going to take no position on briefing. We ask for speed. This has been 10 months coming. We've heard a lot of evidence. To me, it seems rather overwhelming, but that's my opinion. Obviously, it doesn't matter. But so we just ask for it to move quickly.
Thank you. All right. Right, having heard from the parties, I will go ahead and allow, I'm granting the request for briefing as it relates to probable cause to allow both parties to file the briefs. With defense, as you are the moving party requesting briefing,
Like a man.
when would you like to submit your brief? Or to the
Judge,
state.
because we have the burden, I believe it's appropriate for us to initiate the briefing
Okay.
because we're moving for the bind over, and then we would have an
Makes
opportunity
sense.
to reply.
And that's, okay, so let's start. Mr. Grunander, when can you have your brief filed?
Just a moment, Judge.
Thank you. And in going to defense, well, I'll follow up with you as well.
Thank you.
Jerky Chick for the 5. Pray for Erica Kirk and the Kirk family. Absolutely. Absolutely. Thank you so much for that, Cherokee Chick. Bart saying, are they finished up tonight or are they calling another witness today? Oh, they're finishing up for the night. They're just discussing what they're going to do tomorrow, I guess. Because tomorrow was supposed to be pretty much a straight ruling. And now they're going to introduce another witness tomorrow. So, don't know how that's going to go. Oh, they're being quiet about it.
One moment, Mr. Grunander. I'm trying to get logistics so we can move this along.
So excited.
Mr. Grunander, turning to you.
Judge, if we were able to collect the transcript
Tell
Monday,
you guys something.
if we had 2 weeks from Tuesday, we could have our motion in. I believe that's the 28th of July.
All right. So state's brief by the 28th of July, assuming that they can get the transcript by Monday. All right, state's brief. Okay? Ms. Visser.
We need 2 weeks after that, so August 11th, I believe, is 2 weeks.
All right. And to the state, if you wish to file a reply, when...
It would be 7 days after that, Judge. So the 18th?
August 18th. All right. And for oral argument, what I can set is September 1st in the morning. Let me take a quick glance here at the calendar. I'm trying to keep
Papa
that
Sushi,
close in time
Owasso,
so we can move
Oklahoma.
this along for all reasons
Nothing's
previously
better.
stated. And we can start at 10 a.m.
Mommy?
10 a.m. on September 1st. How does that look for the parties?
This one over here was the Full Metal Alchemist.
That works for the state.
This.
Your Honor, I'm going to be in trial that week, and I'd really like to be here for this argument. Is there any way we could just do it the next week?
Well, the problem is, I'm happy to look, but it is getting it would be very tricky. This is a fortunate opening.
Got it. All right.
Otherwise,
We'll take it then.
Okay. I appreciate you accommodating the court schedule. September 1st, in person? I see the defense nodding yes.
Yes.
Yes,
State?
please.
All right. September 1st at 10 a.m. It sounds like up to 2 hours per side, and then we can take it from there. Mr.
So we're going to be in court again
Judge,
September
page
1st
limits.
as well?
We spoke as a team, and our preference would be to limit at least the initial briefs on both sides to 30 pages, no longer than 30.
Defense stipulates to that?
I'd like to counter with 40.
Okay. Well, this is not an auction, but
This is not an option.
any final thoughts?
We'll submit it, Judge. And then we would ask for half of whatever Your Honor grants for the final reply.
We will set it at 35 pages, and then we will go half of that, which is an odd number, 17. We'll go 17 pages for the reply.
Okay.
Parties agree?
I'll tell you what this is in a second.
I know.
We'll take the 18, Judge.
All right, we will go with 18. So 35 pages for the initial filings, 18 response, and September 1st at 10 a.m.
Okay.
Anything further for this evening?
Yes, Judge, I believe the Kirk family, there's a ruling that was reserved by
10
the
a.m.
court.
Utah time. It's
with
Mormon
respect to
time now.
publication of an exhibit that probably needs to be addressed.
Yes, and now
But
my
heck yeah,
understanding
Grits.
is what's being requested is
You know
the
what's up.
portion that had been altered, which I believe is about 1 minute.
Mexican sushi. Ugh.
Your Honor, I believe it was enhanced in that it was like zooming in and circles that were put on it. We would ask for the entirety of that exhibit to be displayed in court. So I believe it was about 8 minutes, if I'm not mistaken. But don't hold me on the.
You all said you would argue this tomorrow.
Any final input on that? Thank you for reminding me from defense. Any final inputs? All right. What we can do is at the conclusion of defense's presentation of whatever witnesses they're going to do, we can address that. So the concern I heard was that the victim representative wanted to see what the court would consider before bind-over decision is made, and that allots for that. So whether it happens right now, which the hour is late, or by right after the conclusion of evidence, that's going to happen well before I consider bind-over. So in the interest of justice and balancing that, I don't want to take away time. It sounds like we're going to be okay, but I always want to be cautious. But I will grant that request, and that will be played in open court, and we will watch the totality of, I believe it is State's Exhibit 12.1, which is 8, give or take, 2 minutes.
Your Honor, and just to clarify, it will not be televised, correct? It's only for people in the courtroom.
That is correct. Because the request was made by the victim representative who is present in court,
right.
I will grant that request, and it will be played in the courtroom for all present to see, but not to be broadcast on TV.
And we just would like a continuing objection for all the reasons we raised before, Your Honor.
Thank you. I appreciate you making that record. I note the standing objection. That objection as it relates to this request is overruled, and that will be played at the conclusion of defense's presentation of evidence and before the state, if they do have a rebuttal witness. Please remind me so that I can address it, and that is taken care of. Thank you to the parties. I'm hesitant to ask this anything further.
Yeah, it's funny.
All right,
Nothing further from the state.
All right, thank you all. I appreciate your hard work today, and that concludes court. We are in recess till 9 o'clock tomorrow morning.
Don't go anywhere yet, guys. We got some stuff to talk about here real quick. First thing, I do want to show you this. This is called a Dragon Ball. It is a deep-fried rice ball with cream cheese and crab meat all in the middle of it. That's what that is. These things are like $4, and they are so dense and heavy, I can usually only eat half of one, and the other half goes to the wife. So, there's that. Anyway, just wanted to show you guys that real quick, but that's not what's important. Now, here's the deal. I'm going to pull up this core lock round thing, okay? This was not shown actually so that box of ammunition here is not shown in the trial. What is shown in the trial was the bullet. You could see the blunted gray-tipped round, and you see it on all of them. These are core locked. You could see them right here on this. This is a soft insert that makes the bullet expand when it hits. So that way, it'll fragment off instead of punching right through. Knowing that, this is the expert that had the foldable AR. Do you all remember him? This is Corey, I forget his last name. He ended up saying this line right here.
I mean, I've had a guy that was a sniper, a Marine sniper, that said he's seen all kinds of crazy stuff. And this was just last week. And he could envision a 30-06 core lock possibly doing that, but
In the neck.
yeah,
That's the problem. It's the neck. Like, it's like,
She's trying to lead him to say, but he flat out knows. Okay? Because Candace Owens says,
I don't know. Pieces together.
Let's see.
How much that bullet, and you'll be bullet and go through and shot with
Where are we?
subs. I heard somewhere there was of
What
those
is Candace asking?
is the main point. Okay. Escape. I mean, there's 1,000 different, there's so many theories out there, but people would be able to tell the difference between a subsonic is the main point. Okay.
And so and I'll just describe, the most likely ballistic profile that I would be looking at for this type of day, and I don't see the body.
Mhm.
I'm just here. I haven't even seen pictures. I saw, the immediate aftermath of those videos, but we haven't seen, the body. So just again, if there was no exit and there was a fragment of the bullet found in the body, and I think I heard somewhere that there was other lead fragments found inside. Don't know if that's true or not. But what you're looking at is potentially a subsonic 300 blackout that perhaps wasn't shot with the suppressor installed on it, and
It's so
did
slow.
not
I forgot about it.
did not
It's
go
so
through
slow.
and separated when it hit, and a piece of the jacket coming off and separating. And again, though, if there is no exit wound, you're going to find all the bullet fragments inside, and
That's
you'll
the
be
part I
able
don't get, yeah.
and you'll be able to weigh it, and you will tell exactly or pretty close how much that bullet originally weighed after you get all the pieces together.
Mhm.
And so, if it is true that no fragments left the body, then it will all be there.
It's gotta all be there. It's an autopsy.
And so maybe we're not seeing the whole picture. Maybe some fragments did exit somewhere. I don't know. But I could see a 300 blackout doing that. Even a supersonic blackout could possibly still remain completely inside the body and separate and not penetrate through. 30-06 though. I mean, I've had a guy that was a sniper, a Marine sniper that said he's seen all kinds of crazy stuff. And this was just last week. And he could envision a 30-06 core lock possibly doing that, but
In the neck.
And here we have exactly what he said. Funny how it works, huh? Funny how it works. It's the exact, this is the gun expert, the guy who created the foldable AR. And he's like, I could see a 30-06 core lock doing that. And then we find out the rounds for the 30-06 core lock? Huh. It's funny how it works, isn't it? Anyway, guys, I wanted to leave that to you all here. I think I'm going to probably make a short over this here tonight. Tomorrow, I'm going to get this video out where I show all this stuff. This is wild. Candace Owens ended up debunking herself months ago, and I had a feeling this would happen. But anyway, guys, I'm going to thank everybody for donating, all that good stuff. We have Ashley for the 20. Thank you so much. We have Frankie for the 20. We have B. Barf the Bard. B. Barf the Bard. That sounds like a Mortal Kombat character. Who's that one guy? But not quite. Anyway, for the $10, thank you so much. We have Sweet and Sassy joining as a troll. We have GN Barry joining as a troll. And then we have Cherokee Chick for the 5. Thank you all so, so much for being here. Genuinely, you all are what keep this channel going. You guys are pushing me to new heights. I appreciate it so, so much. I'm going to eat this stuff, and I'm going to go straight to bed. Get up early. I had to finagle my schedule in order to get Tuesday to stream to you guys. So I'm probably... we'll have to see what happens here tomorrow. I got to be up pretty early, but I should be able to get home on time. I should be able to show most of the trial tomorrow. There is an incident I got to deal with at 1 p.m., so I really hope the trial wraps up by 1 p.m. I really hope so. We'll see what happens. If not, I might have to cut the live stream early tomorrow. I don't know that I will stream Saturday. Yeah, it's because of all this whole week of streaming's been nuts. I was not as prepared to stream as I thought I was. Things happen. So, but I made it work. Managed to stream. Thank God it worked out. Monday, obviously, I could not stream, which sucks. But anyway, thank you all so, so much for being here. Thank you, Brusha. I appreciate that. Let's see. Yeah, thank you all so much for being here. I'm going to try and get this wrapped up pretty quickly here, too. I'm going to try and make that short tonight. Thank you all again, and I'll see you all here in the next one. Later.